All right, chapter 6, estates and interests. We're going to learn about what is an estate. Um, so, in this chapter, we're going to identify the characteristics of what is an estate in land. We're going to describe the characteristics of encumbrances and learn about things like liens, easements, and encroachments. So, let's start off with the term estate in land. Now, this particular chapter is talking about ownership category of estates and land. So naturally, they're just going to be mentioning it pertaining to ownership. But the definition, the more proper definition, rather than the one that just says it describes the amount or kind of ownership interest in land, um, let's just change that definition a little bit by crossing out the word ownership on page 103. And an estate in land describes the amount and kind of interest that a person has in real property. Because there's two categories of estates and land. This chapter is going to be going over the category of freehold estates, which describe ownership. And then in chapter 12, when we get to that, we're going to be talking about the leasehold estates. That's the category of leaseholds or less than freehold. So this chapter, we're going to go over the three types of freehold estates. We'll mention at the beginning the four types of leaseholds, but we're not going to dive into it with any specificity. We're going to get deep into the freehold estates. So what is an estate in land? It describes the amount or kind of interest that a person has in real property. And there are two categories of estates and land. Freehold is the category of ownership, and the less than freehold is the leasehold estates. So let's get into the freehold estates here. And we'll cross out the word ownership to have this definition of what an estate and land is to be more accurate. And then on the next page, let's write two categories of estates and land above it, and then highlight freehold estate and write ownership category, three types. And that will highlight leasehold estate, four types. And then you could give the cross reference chapter 12, page 228. That's where we start talking about the leasehold estates in chapter 12. So this is all at the top of page 104. So just write two categories of estates and land, highlight freehold estates, and then write ownership category, three types, and leasehold estate, four types. Chapter 12, page 228. That's what you're going to write there. Everybody got that? Anybody still writing? Okay. So there are three types of freehold estates: fee simple, fee determinable, and a life estate. So let's just highlight freehold estates and then write the number three in front of it, and then just highlight one, two, three, the fee simple, fee determinable, and life estates on page 104 there. So freehold estates are for a indeterminable length. Person can own an estate for their life or forever. Freehold estate, these are the freehold estates that are recognized in New Jersey, and the first two of these estates continue for an indefinite period of time and are inheritable by the owner. The third estate ends on the death of the person whose life it is based on, the life estate. So, before we get into those estates and land any further, let's talk a little bit about the leasehold estates. There's a little sentence there that we're going to highlight on page 104. Leasehold estates involve tenants and are estates for a period of time. Leaseholds are considered to be personal property, not real property. So it is an intangible or incorporeal asset. Because it's leasehold estates about your rights to occupy someone else's property. So leaseholds involve tenants, and a lease signifies the tenant's right to occupy an owner's property for a limited period of time as defined in the lease. Leases involve tenants. The tenant is the lessee. The owners are known as the lessor, because remember, words that end in OR is the person that's giving whatever the root word is, and it's the lease. And lessee, words that end in EE is the one that receives it, the lease. So a lease is personal property. It's an intangible or incorporeal asset. It's not considered real property ownership because you don't own the property. You only have the right to occupy someone else's property for a limited period of time. That's what a lease is, right? So a lease describes the tenant's right to occupy someone else's property for that limited period of time, as is defined within the lease itself. And as well as the terms, the length of time, what's being leased, and any limitations on the estate. So there are 4 types of leasehold estates we'll go over in chapter 12, not now. There's the estate for years, a periodic estate, a tenancy at will, and tenancy at sufferance. Those are the 4 types of estates in land for leasehold. So let's get into the 3 types of freehold estates. And you can highlight and take your notes there, right next to the title here. Ownership forever without restrictions, next to fee simple estate. It is ownership forever without any restrictions. It's the highest form of ownership recognized by law. And a fee simple estate goes by 3 different names: fee simple, or fee simple absolute. It's all describing the same estate and land. The highest form of estate and land recognized by law. It's ownership forever without restrictions. Even when you die, you get to say who gets your stuff, who gets your estate. That's a fee simple estate. Fee simple, absolutely. So fee simple, or fee simple absolute. Then we have the fee determinable estate. This is ownership forever based on a restriction. That restriction, those restrictions placed in deeds are called restrictive covenants. Covenants, a legal promise. So these are restrictive legal promises. So when you take ownership as a fee determinable estate, it too is ownership forever, but that ownership is based on a condition, a restriction usually. As long as you don't violate that condition, you remain the owner. You violate that condition, well, there's the possibility of reverter. What does that mean? That the ownership can revert back to the previous owner, or the one who put the restriction in the deed to begin with, that you agreed to when you took ownership. And if you violate that restriction, well, you got ownership forever unless you violate that restriction, and then it could revert back to the person who put the restriction in the deed. And if they're no longer around because they died, it would go to their heirs, because their heirs are the beneficiaries of their rights, right? So, or they could have named somebody else to be what's known as a remainder man. That would be the person who can be the beneficiary in the event that you do violate that restriction. So that's what a remainder man is. A remainder man is a third party named in an instrument, a document, to be the beneficiary. So yeah, you could add that term to your definition list there too, remainder man. And then a life estate is ownership. It is ownership that is based on a restriction. I'm sorry, it's based on your life, not a restriction. A life estate is ownership, but it is ownership based on the life of the person, based on a life. Okay, let's just say that, based on a life. So a life estate is limited to the life of a specific person. The owner of a normal life estate does not have the right to pass ownership onto their heirs because when they die, they lose the ownership interest. Okay, so the person who a life estate is ownership based on the life the estate is given to. Okay, but there is another version of a life estate. This is why I wanted you to put the definition there, is ownership based on a life instead of the life of the person it's given to. Because there's a little bit of a change to this as well when we have what's known as a life estate por otra vie. Por otra vie means for the life of another. So you could have a normal life estate is based on the person of the life of the person it is given to. They can't leave it in a will to their heirs because when they die, they lose the ownership. It reverts back to the person who gave it to them. So a life estate does have that reversionary interest because you will lose that life estate when you die. But you have the ownership as long as you're alive. Now, a life estate por otra vie is not based on the life of the person it's given to. It's based on a third party's life, someone else's life. Okay. We'll get to that term por otra vie in a moment, but I just wanted to bring it up. That's why I wanted to have this definition here as a life estate is ownership based on a life. Let me know when everybody got all those highlights and notes written down and underlines. And then we get to my slides, which we'll go over this again. Okay. Everybody good? Everybody got the highlights and the notes, or anybody need a minute? No? Okay. So to do the recap on the three types of freehold estates, what is the category of freehold? What does that mean? Free to hold it forever or a lifetime. It is the category of ownership. So it goes by fee simple. This first one goes by three names: fee simple, or fee simple absolute. It's the highest form of ownership recognized by law, most complete form of ownership. It is unrestricted ownership forever. Ownership without restrictions. Even after you die, you get to state who will inherit your estate. Then we have a fee determinable estate. Also goes by the name defeasible fee or conditional fee estate. So it goes by three names too. Fee determinable is also known as a defeasible fee or conditional fee estate. It's ownership forever, but that ownership is based on a restriction. And as long as you don't violate that restriction, you remain the owner. Those restrictions that are placed in deeds, and we call them restrictive covenants. These are the legal promises you agree to abide by. And if you violate that restriction, and the person who put that restriction in there finds out about it, they can take you to court and demand that you turn the property back over to them without any compensation, by the way, because you violated the terms of the sale that you were perfectly aware of. So only private parties can place restrictions in deeds, not the government. The government has their own powers on how they can restrict how you use your property through zoning laws and building codes and things of that nature. But the restrictions placed in deeds can only be put in there by private parties, private owners, not government. So if the restriction is violated, ownership would revert back to the person who placed the restriction in the deed. This is called the possibility of reverter. It's possible if you violate that restriction, the ownership reverts back to the previous owner that put that restriction in the deed, or to a remainder man. That's a third party named in the instrument to be a beneficiary. Now, the restrictive covenant runs with the land, because now if you buy that property with a restriction and then you go to sell it, what are you passing on to the next owner? All the rights that you had in that property, and those rights are now limited in some way. So you can't create any new rights for a property when you sell it. You can only pass along those rights that you possessed, and they're already restricted. Make sense, everybody? So They pass on to the next owner and can only be removed by the person who added the restriction to the deed, or their heirs, or by a court, but courts are not likely to overturn those restrictions. And then we have a life estate, which is ownership, but it's based on the life of the person the estate is measured against. They can't leave it by will, and they have all the rights of ownership to sell, lease, mortgage, give away the property, but they cannot destroy its value. Got to pay its taxes, because if you don't pay taxes, you could also lose that estate. And upon the death of the ownership, it reverts back to the person who gave the life estate to the or to a remainder man or the heirs. You guys all heard of Hugh Hefner before? The guy, the owner of Playboy magazine, Playboy Mansion, right? Well, did you know that Hugh Hefner, he sold the Playboy Mansion when he was still alive? He actually sold it with the condition that the buyer who bought it from him gave him back a life estate so that he could live out the remainder of his days in his beloved mansion, his Playboy Mansion. So he had a life estate. That's an example of where the life estate is. But this is a famous one because we get people often, they ask, well, have you ever come across this? Have you ever seen it? No, but they're around. You can see here with the life estate, right? You can see here with the life estate, Playboy Mansion for sale. This is from the Realtor.com. Playboy Mansion for sale with one tenant for life. This is an actual picture of the Playboy Mansion. Somebody put up this for sale with owner. Right? Well, that's essentially what it is. You're buying the property with the owner. You know, he says, I'm not leaving. You're buying the property, and then you're going to give me the ownership back for the rest of my days. The condition was, I think he had to pay the taxes on the property, and I think he had to pay like a dollar or $1,000 a year for the to live there. That was the condition. So Hugh Hefner's Playboy Mansion, it was a bit run down, to say the least. You know, he had his three little lap dogs that were not potty trained, so the Playboy bunny said. So, you know, they lifted their leg, peed, and crapped wherever. You know, there's a lot of endless parties that were going on here. It was not updated, the decor. Got that old carpet in there. It's all nasty. Roof leaks, all kinds of other issues in the Playboy Mansion. You know, it's difficult to maintain a mansion when you got parties constantly going on for years and years and years and years, right? So it was a bit run down, needed work. So yeah, 29 room, 6 bedroom Beverly Hills mansion was in decrepit condition. Its owner, Playboy Enterprises, hopes to sell it north of $200 million. Plus, the buyer will have to grapple with another huge catch. The 89-year-old Hugh Hefner got a life estate, which means that he could continue living there until death departs him with his beloved Playboy Mansion. Right? Well, the owner lucked out when they sold him that Playboy, when they bought that Playboy Mansion. Well, let's see, how much did it eventually sell for? Anybody ever hear of this story before? They were looking for $200 million. I think they got more along the lines of $100 million for it. Their experts were saying it would be worth more like 80 or 90. I think he got $100 million for it. So why did Hugh Hefner sell the Playboy Mansion? Does anybody know? I mean, Hugh Hefner was already past his life expectancy of 84.3 years of age for the U.S. male's life expectancy, right? And when he sold the Playboy Mansion, he was 89 years old. So I mean, the buyer was like, I mean, how much longer can this guy live? You know, so he bought it, and he did luck out because Hugh Hefner only ended up living there for 1 year before he died. You know, when he sold it. But why did Hugh Hefner sell the Playboy Mansion? Well, because he needed money. that Playboy lifestyle ain't cheap. Magazine sales with the internet and you get your free porn online and all that. It's not exactly like there were people were buying the magazines flying off the shelves anymore. And Hugh Hefner was already retired. He was just a figurehead, for the Playboy magazine. He had Playboy TV and all that. But then, of course, you've got the modern times. Hugh Hefner's daughter was running the Playboy magazine enterprises for quite some time, quite a few years already, successfully. But then she didn't want to do it no more. She wanted to do something else. So Hugh Hefner turned it over to his son. Now, his son, living in California and being extremely woke and modernized, he came up with the bright idea of we're going to shake things up a little bit here at Playboy magazine. And so he introduced the first transgender centerfold. Obviously, not what their normal readership was expecting to see when you open up a Playboy magazine centerfold. So people canceled their subscriptions at an alarming rate after that. But so they didn't make he didn't make the business run any better. So Hugh Hefner really needed that money. And so he sold that Playboy magazine, that Playboy mansion for about $100 million to some 40-year-old that lived next door. Must be nice, right? You got a 40-year-old guy living next door who can afford a mansion in Beverly Hills, and then he buys his neighbor's mansion for $100 million. What the hell did that guy do? Well, it was some Greek fella. He owned a bunch of brands, like Pabst Blue Ribbon and all kinds of food brands and things of that nature, like Nabisco and stuff like that. I think his father was in the same business. They were just like the family business is owning brands. Like brands of all the foods that we eat. That's where that 40-year-old guy got all that money, all those billions. All right, so that's an example of how a life estate would work. Now, Playboy Mansion is in quite decrepit condition, but what does the Playboy Mansion look like today after renovations? Let's click on that and we can actually see. Okay, so you go. You got Hugh Hefner there in his silk undies, his silk wear. Here's the guy who bought the mansion, Darren Metropoulos. Okay, he bought it for $100 million in 2017. The property underwent 5 renovations. Let's see. So this is the full Playboy mansion there. Oh, look at that. They got the skylights in here. So they redid it a bit. This is what it looks like after they redid the Playboy Mansion. Should have seen the befores. they don't look too great. All right, I'm not going to spend a lot of time on that though. So we also have the life estate pour autre vie. Okay, no. It is not French. I know people argue it's French. That's how it means in French. You pronounce it the same way. No. If it was French, it would be P-O-R. This is Latin. It is P-U-R. Pour autre vie. Life estate pour autre vie, for the life of another. Add that term to your definition list as well. For the life of another. Life estate pour autre vie. Not based on the person whose life it's given, it's based on someone else's life. And there could be many scenarios where that would take place. And then we have, okay, so now these are just recap slides, Fee simple, ownership forever without restrictions. Fee determinable also goes by defeasible or conditional fee. It's based on a condition. It's got that possibility of reverter, right? That it would revert back to the person who put the restriction in the deed or another person that calls a remainder man. Then we have a life estate per otro vis, for the life of another, based on someone else's life. Now, the holder of a life estate has true ownership of real property. They have all the rights and benefits as any owner. It's just that they cannot leave it in a will to their heirs. They cannot destroy the estate's value. They need to maintain it, and they could sell it, lease it, give it away. But whoever gets it got to realize that when the person who gave it to them died, whoever's life it was based on, they lose it. So how do you value selling a life estate? See the person whose life it's based on, hopefully they're in great medical health and they don't get hit by a bus tomorrow, right? Because if they do, you lose the estate upon their death. All right. So life estate is ownership based on a life. It's got that reversionary interest that goes with it. And on page 105, we could highlight a life estate por otra vie, for another's life. The holder of a life estate has true ownership of the property, but it always ends on the death of the person against whose life it is measured. And so get those highlights down from page 105. Everybody good? All right, so this is the way that a life estate works. You know, the grantor, they give title to the life tenant, and when the life tenant dies, the ownership goes back to the grantor, the person who gave you the ownership. But if they're dead, it would then go to their heirs or devisees that they left it to in a will, or to a remainder man if one was named. So here's how a remainder man works. The grantor gives the title to a life tenant. Upon the life tenant's death, then it goes to the remainder man or the devisees, heirs or devisees, if they're not alive. All right. Dower and courtesy, we learned about this already, right? We were introduced to this in the last chapter, even, I think, and the chapter before. Dower and courtesy rights. You know, dower begins with a doe. And what's a doe? A doe is a deer, female deer. So the dower is the wife's right, and courtesy, because men should be courteous to women, is the man's right. So dower and courtesy are ancient rights that a spouse has in their spouse's property. A dower is the wife's interest in her husband's estate upon his death, and courtesy is a similar right that the husband has in the wife's property upon her death. And New Jersey abolished the creation of new dower and courtesy rights as of May 28, 1980. You need to know the date, and you need to know that dower is the wife's right and courtesy is the husband's right. And I just gave you a way to try to remember that. Remember that dower begins with a doe, and a doe is a deer, female deer. So the dower is the wife's right, the female's right, and courtesy is the man's right, the husband's right. And New Jersey abolished the creation of any new dower or courtesy rights as of May 28, 1980. Instead, now they give both the husband and wife joint possession of the primary marital residence. Okay, so when one spouse dies, the other inherits the primary marital residence. The other properties, well, they could leave them to whoever they want. But the spouse is entitled to 1/3 of the estate. Remember that. So your spouse can't write you out of the will completely. They have to award you at least 1/3 of the estate if you were married to them when they died. I mean, they could leave you less in the will, but then you could be like, nah, I'm going to exercise my right of election instead and opt for the larger share that you should have left me, a minimum of 1/3. That's what the right of election is. So even if they
But
write you out the will, you could still claim 1/3 the estate. Go ahead, Aaron.
but that's only for people who were married before that date.
No.
That
Uh,
the
the right of election is oh wait, yeah, it is before that date, because after that date, it's only for the primary marital residence, but your spouse still has to leave you a portion of your estate. I think it's a half now.
okay.
So half is larger than 1/3.
Thank
But
you.
that's the right of election. Okay, so dower and courtesy rights here. We can do the highlights now. Page 105. Dower is the ancient right which a wife has certain interest on her husband's death in any real estate he owned during their marriage. Courtesy is a similar right the husband retains in his wife's estate. And as of May 28, 1980, New Jersey abolished the creation of any new dower and courtesy rights, but any existing ones are still in force. Instead, now they give both the husband and wife, the right of joint possession of the primary marital residence. The real estate broker must learn which rules apply, because you could have only one spouse listed as the owner, but the other may have interest in the property depending on when they were married, right? So the real estate broker must learn which rules apply in any specific case in order to be aware who needs to sign the documents to list the property or to sell it. So where both the husband and the wife are listed as the owners, of course, they both need to sign any relevant documents. And in many cases, a non-owning spouse must agree to release claims of dower or courtesy or possession by signing a listing contract, sales contract, or deed. This is why we need to know about dower and courtesy rights. Now, for real estate owned during their marriage by one spouse before May 28, 1980, a surviving spouse has the rights of dower and courtesy, and any related documents should be signed by both spouses, even if only one is listed as the owner. If the family home is being sold, the main marital residence, all documents need to be signed by both spouses, even only if one is listed as the owner. And any real estate acquired after May 28, 1980, that's not the family home, may be sold by only the one owner without the signature of the other spouse. The seller should, however, consult an attorney before signing any documents without their spouse. Everybody good with the highlights? Yes?
Yes.
Okay. Encumbrances. You guys ever hear this word in your life? Not having to do with real estate, just the word encumbrance. Have you ever heard of the word encumbrance before? Anybody? Anybody? An encumbrance is something that weighs you down. For instance, let me draw you a picture. If I were to jump on your back and hold on, are you weighed down? Are you being held back or held down by my weight? Yes. Is it harder to move around? Yes. But can you still move around? Yeah, possibly, right? You're depending how much I weigh, right? I jump on your back, you're encumbered by my weight now on your back. But can you move around still? Yeah, it's just a lot harder to. So have that picture in your mind anytime you hear the word encumbrance, because we haven't even gone over types of real estate encumbrances yet. but the same situation applies to those. Can you sell real estate if it's weighed down by something? Yes, you can. It's just a lot harder to. Just like if I jumped on your back, can you move around? Sure, it's just a lot harder to. So if real estate's encumbered by something, can you move it, sell it? Sure, it's just a lot harder to. So now that we have that understanding, then let's get into the definition. An encumbrance is a burden on the property. It's a claim, lien, charge, or liability attached to and binding on real property, limiting its value or title. Liens are financial claims on property. You have mortgage liens, tax liens, lawsuit judgments, and mechanics liens. Then we also have physical or usage encumbrances like deed restrictions or easements, licenses, and encroachments that can limit how the property is being used. Here's a little brain teaser for you. All liens are encumbrances, but not all encumbrances are liens. And we could better understand that if we translate these words in our head as we read this. What's a lien? It's a financial claim on property. So all financial claims on properties are encumbrances. Encumbrances are burdens on the property. So all financial claims are burdens on the property, but not all burdens on property are financial claims. See, when we translate the words in our head like that, it makes a lot more sense. So this is why we need to know our vocabulary. So if they give us a question with these words in it, you translate them in your head so that you could better understand them, and then you'd understand what the question's asking of you. So we could do this highlight here for encumbrances, liens, physical and usage encumbrances, and that brain teaser like I had on my slide. It's right here in your book. That's on page 106 under encumbrances. Okay. Try and help somebody get into the meeting here. For some reason, they're having trouble getting in. Okay, everybody got that? Moving on. Liens are financial claims against property that provide security for debt or obligation of the property owner. So if the obligation is not repaid, the lien holder or creditor has the right to have it paid out of the property, usually from the proceeds of a court sale, like a foreclosure sale. Liens are classified either as voluntary or involuntary or general or specific. Voluntary lien is something you wanted. Involuntary lien is something you don't. General lien affects all property you own, and specific lien affects only one parcel of real estate. So we'll highlight now that a voluntary lien is created by the property owner, and involuntary lien is imposed without the owner's consent. And general liens affect all property someone owns, and a specific lien only affects one parcel of real estate only. See, general liens apply to all your property, not just real estate, even your personal property. So when you hear general, it's a wider scope. Okay. Still highlighting, or anybody need another minute? Okie doke. No questions. So liens are financial claims against property. Well, hold on. Let me pause this for a second and give this person a call. They're having trouble getting into the class. Let me give them a call. I'll be right back. Let me just pause this really quick. So liens, once again, a lien is a financial claim against property that provides security for a debt or obligation of the property owner. Voluntary lien is created by the owner. Involuntary lien is created without the owner's consent, like your property taxes. Nobody wants to pay property taxes, but you're imposed with these liens that you need to pay. Everybody got to pay their property taxes. The voluntary lien that was created by the owner is like your mortgage loan. You went out of your way to get that one, right? But that creates a lien on your property. And general liens affect all property you own, both real and personal property. In general, remember when speaking in general, it's a wider scope, whereas a specific lien only affects one specific property. Okay. Some examples here, as you can see in these little images they have in our book. Utility lien, it's specific. It only affects the one property you didn't pay the utilities on. Special assessment, that's a improvement tax that all property owners pay for improvements the municipality does. If they did improvements in your area, in your section of town, only the people who are to benefit from that improvement will pay for that improvement. That's a type of property tax that's charged by the municipality, but only to the owners of the properties in the area where the municipality did improvements, not where the property owner does improvements. Okay, that's known as a special assessment lien. And then the ad valorem tax, that's the general real estate tax that everybody pays. It's based on the value of your home. And that's what ad valorem means in Latin. It means according to value. So we'll learn about that in chapter 8, the tax chapter. Now, mortgage liens only affect the one property. If you don't pay your mortgage lien, only that one property can be foreclosed on. It doesn't affect any other properties that you may own. Contractors liens, these are mechanics liens. They're specific. It only affects the one property. Vendor lien, I'm not sure what they mean by a vendor, but okay. So general liens, they affect all property that you own. Like if you get a lawsuit, a judgment against you, somebody finds out that you own property, they could put liens on all the properties that you own so that they could get paid back. Estate and inheritance tax, deceased person's debts, corporate franchise taxes, unpaid IRS income tax. These are all general liens that affect all of a person's property, both their real and personal property. So what are the effects of liens on the title? Well, liens do not attach to the property owners. Liens attach to properties, not to property owners. So if you have a lien on your property and you go to sell it, well, it passes along with the property. So buyers beware. Caveat emptor. Do your due diligence before purchasing a property. Make sure that there's no liens on it, because liens attach to the property, not to the property owner. So they're still binding even after the sale. So when you're buying a property, you want to do that title search, make sure there's no liens on the property, and make sure the owner pays them off so they don't become your responsibility. So liens attached to the property, not to the property owner. Okay. So in most cases, the next owner is not personally responsible for the debt secured by the lien, but they could lose the property if the creditor took court action to enforce repayment of the lien. And they do that by foreclosure. Now, I have here a little write-up about foreclosure you'll not see in the book. Taxes get paid first in the event of a foreclosure sale. If any money is left over, the liens get paid back in the order in which they were recorded until there's no money left. So first lien holder gets paid back first. If there's any money left over, that money goes to pay off the next lien holder, and so on and so forth until there's no more money. But if there's plenty more money, then all the lien holders get paid off, and whatever's left over goes back to the property owner. That's their equity they had in the house. It is possible for you to get foreclosed on and you had one payment left to be made on the house. So you practically paid it all off, right? But it is possible to still be foreclosed on if you did not make that last payment. The lien holder just wants to get their money back. So they're not looking to sell it at the highest and best price they possibly can. Well, they put it through foreclosure auction, but that's not going to get you the best possible price. That would be by putting it on a regular market, you know. This is for a quick sale at the best price is an auction. But if the owner were to sell it in a traditional fashion, they'd be able to get more money for the house probably. So, because who goes to auctions to buy property? You know, people, bargain hunters, right? Investors, bargain hunters. But in some cases, you could still sell a property at an auction and get enough money to pay off all of the debts and still have some money left over. If that's the case, that extra money goes back to the property owner. That was their equity that they had built into the property. So in some cases, if a property owner is in danger of foreclosure, were to sell the property, which had a lot of equity, they would pay off all of their debts and still walk away with a nice profit and keep their credit in good standing. However, sometimes people fall on hard times, let the problems sort themselves out, and then foreclosure ends up inevitably happening. And if there are enough proceeds to pay off the debts, then the homeowner will still get the remaining money back. But if they sold it themselves, they would have received even more money than what they would in an auction sale, most likely. Okay, so once again, encumbrances, liens, and other kinds, they run with the land. They pass on from one owner to the next. Liens attached to property, not to property owners. And real estate taxes have first claims against any such liens, right? Two things certain in life, death and taxes. You need to pay your taxes even after you die. So real estate taxes have first claims against any foreclosure liens. They need to get paid off first. So we have voluntary liens. Those are liens you wanted, you went out of your way to get, like a mortgage loan or a home equity line of credit. Involuntary liens are things like real estate taxes. It's a specific involuntary lien. It only affects one property. If you don't pay your real estate taxes, it only affects that one property. And it is involuntary because who wants to pay taxes, right? Those are, you didn't want to pay them, but they were imposed on you. Unpaid federal income taxes from the IRS, well, that's a general lien and it's involuntary. Lawsuit judgments, those are general involuntary liens. Once again, involuntary lien is something that was not created because the owner wanted it. Voluntary liens were created because it's something you wanted. And then we have unpaid child support. Okay. That's a general lien against all your property, and it's imposed on the property owner. It's not a lien they went out of their way to get, even though they did contribute to it. That last one, anyway. Now, satisfaction of liens. When your liens are paid off on your property, liens are never removed from the public record. They're there forever. Okay. So when you owe somebody money, it creates a lien on the property. When you pay them off, the lien is not removed. It remains there forever. They just add another document to the public record called a satisfaction of lien that says that that lien had been paid off. So now if anybody in the future wants to do a title search of the history of the property, they can see, there was liens on the property, and then they match it up, those liens were paid off, because nothing was ever removed from the public record. Once it's there forever. Okay. So all they do is they just add another document to remove that lien. And any liens on the property create what's known as a cloud on the title. Think of a dark thunderstorm, cartoonish cloud just hovering over your house and nobody else is in the neighborhood. That's an indication or maybe a problem, right? You had that dark thunderstorm cloud hovering over only your house in the neighborhood, right? Have that image in your head when you hear the term cloud on title. Title means ownership. Cloud, think of that dark thunderstorm cloud hovering over the house. There's a problem with the ownership. Okay. You got to clear that title up before you're willing to take on that ownership, right? The clause on title could be liens that the seller never disclosed that are on the property. Or maybe there was an improper transfer in the past where not all of the property owners signed the deed to transfer the ownership. And this comes up in the title search now. There's always that possibility that that unknown person can step forward and claim their ownership of the property because they never signed off to sell it, right? So that creates a cloud on the title too. Now, these issues can be cleared up in different using various methods, but this is right now we're just talking about discovering these problems, and those are known as clouds on the title. Okay, we remember this, showed this to you in chapter 20. The action, person dies intestate, no heirs can be located. The property, through the process of escheat, reverts to the state. If land is needed for a public use, a greater public good, using the powers of eminent domain and a condemnation court hearing and a justifiable payment to compensate the property owner, they could take the property and turn it over to a public or governmental agency. Through non-payment of debt secured by real property, the process is foreclosure. It's a judicial process in New Jersey. And then the sheriff sells the property to the highest bidder at an auction. And through open, notorious, continuous, and adverse use of another person's property for a period of time as defined by law or prescribed by law, an easement by prescription can be perfected through adversely possessing someone else's property. And a suit for possession, adverse possession, or suit to quiet title can be used to get the property and turn it over to the adverse possessor. So what determines the priority of the order in which liens get repaid? Well, liens get repaid according to the date that they were recorded in the public record, with the exception of two items. Real estate taxes, they always jump to the head of the line, right? And mechanics liens, that's a contractor's lien. Those liens can be retroactively backdated. It doesn't matter when they actually record him in the public record. They get retroactively backdated to the date that the work was begun or the materials were delivered, whichever occurred first. So let's highlight those things down here now on page 107. under priority of liens. Here. Everybody got that? Looks like nobody's writing, so I guess you did. So what are the effects of the liens on the title again? Once again, liens and other encumbrances run with the land, meaning they pass on from one owner to the next. So liens attach to the property, not to the property owner. The priority of liens establishes the order in which those liens, those debts are repaid. Taxes take priority over all other liens. Two things certain in life, death and taxes, right? We're all going to die and we all need to pay our taxes, even after we die. Otherwise, they're repaid according to the date they are recorded in the public record, with the exception of a mechanics lien, which its priority is retroactively backdated to the date the work began or the materials were delivered, whichever happened first. That'll be somewhere in the book, but as of right now, yeah. Now, mortgage liens, well, those are voluntary liens you went out of your way to get, right? And those liens are paid back according to the date they're recorded in the public records. Junior liens, that's second liens, third liens on the house, home improvement loans, same thing with them. Judgments, a judgment is a decree from a court saying that you owe someone else money. And when somebody gets a judgment against you and they find out you own real estate, they could turn it into a lien against the property. And other liens. Okay, so let's highlight a mortgage lien's a voluntary lien, page 108. And here's that information about the contractor's lien, also known as a mechanics lien. And a lis pendens. This is also on page 109, lis pendens, right in the middle of the page, or just slightly below the middle. The lis pendens is recorded when you fall behind on your mortgage payments by more than, let's say, about 2 payments. Your lender usually goes and files a document in the public records attaching it to the ownership of your real estate that says that this person is behind on their payments and a possible future legal action could be pending. That legal action being foreclosure. So lis pendens is just a public notice of possible future legal action by a lien holder. That's all it is. It helps establish priorities of those later claims. Are you guys in salesperson mode yet? All right, then let me just bring this up one more time and read what I just read. A lis pendens, it's a public notice of possible future legal action against the property because they fell behind on their mortgage payments. Could this information be useful to you as a real estate agent or even for an investor in some way? If you could get a list of people who are behind on their mortgage payments?
Yes.
Did I just awaken the salesperson in you a little bit now? Well, you can. Here, I put together this slide for you. Here's a couple resources where you can get this. This one you get for free along with your realtor membership. There is a way. I know that you got to look through their tutorial videos. I know there's a way to search for the list pendants lists for properties that have list pendants against them. But if you just sign up for listpendants.com or realtytrack.com or the redx.com, they scour the public record databases to only look up all the information about the pending foreclosures and REO properties. Those are bank-owned properties, and list pendants, properties that have been added, had list pendants added to them. And then you could now have this database of just those properties along with the contact information for any lawyers or that may already be involved, the property owner's contact information and all that. And I don't suggest you go knocking on anyone's door unless you want to get punched in the nose, because look, if you're behind in your mortgage payments, what will you do if somebody starts knocking on your door? Yeah, according to my records, you're behind on your mortgage payments. Yeah, so what do you want? Get the hell out of here, right? It's the kind of response that you could expect at the front door if you knock on someone's front door. Same thing as if you call them up, what kind of response do you expect? You call somebody up and say, yeah, according to my records, you're behind on your mortgage payments. Well, who the hell is this? How do you know? They're not going to be happy to talk to you about this, right? Especially some third party that's not their lender. So I would suggest a soft introductory by using a postcard or a letter sent to them. And just use like real words. Don't use any industry lingo like underwater on your mortgage, we can help. I see those things all the time with houses floating on water. It's like, what are you selling here? You got to think of the layperson, the average person out there, not using the real estate industry lingo. Your home is underwater. That means that you're behind on your mortgage payments, in danger of foreclosure, or going through divorce, or things of that nature. Don't use that terminology when talking to the public. Remember, I told you, keep it simple, stupid. Use that strategy to your advertising as well. Make it easy for people to understand things. Behind on your mortgage payments, we can help, right? That's a better strategy. It's direct, straight to the point. It's understandable, it's relatable. Behind on your mortgage payments, we can help. And you just keep sending these because they probably won't respond to you with only one mailing. So you're going to have to send these mailings several times to them before they finally eventually may reach out to you. Okay. But then that's a listing right there. That's a short sale or pre-foreclosure sale, right? So the public notice gives possible future legal action of foreclosure that is pending and potentially affect the title to a specific parcel of real estate. It creates the cloud on the title. It gives notice to all interested parties, including prospective purchasers, that someone has an interest in the property. And lenders will place a list pendants in the public records anytime the owner falls behind like 2 months on their mortgage payments. And here's the resources I gave you for list pendants lists. Okay, an easement is a right acquired by one party to use the land of another for a specific purpose. That's what an easement is. It's a right to enter one party's property and use it for a specific purpose. That's an easement. It's a right. And if somebody has a right, can you take away their rights? Can you violate their rights? Can you take away their rights? No. Once somebody has rights, that's their rights. Rights cannot be revoked. You could give up your rights, but they can't be taken from you. So let's highlight a right acquired by one party to use the land of another for a particular purpose as an easement, and underline the word right. You may even want to write that next to the title, easement. Rights that cannot be taken away, or rights that can't be revoked. So the holder of an easement only has rights to the property. not an estate or ownership interest in the property. So easements may be either appurtenant or in gross. We'll learn what that means in a moment, as we learn about the different types of easements. But right now, we just learned that easement is a right to enter someone else's land for a particular purpose. So, an easement appurtenant is an easement that grants the right of the owner of an adjacent parcel of land. Is an easement appurtenant. Adjacent is your neighboring property that's touching yours, not the person across the street or down the block. It's the neighboring property that's touching your property. Okay, that's what adjacent means. So for an easement appurtenant to exist, there has to be two adjacent tracts of land that are owned by different parties, because you don't need an easement to cross over your own land. The tract over which the easement runs is known as the servient estate, kind of like the servant, the servient. They're serving up their properties for someone else to walk over it. And the tract that is to benefit from the easement, the one that's walking all over your property, is known as the dominant estate. So you have the servient and the dominant estate. Who usually benefits? The bully, right? The dominant. Not that they're a bully. They actually have a right to walk onto your property and use it. But it's your property and you've got no say about it. So I guess it is kind of like that bully situation, right? This person has a right to walk over your property and there's not a damn thing you could do about it because they have a right to. Now, an easement's said to run with the land. So once an easement is created, it's there forever. It runs with the land. Passes on from one owner to the next. Then if you sell your property, that new owner needs to honor that easement. That next servient estate owner needs to honor that easement as well. You don't lose your easement right because the owner of the property sold it. You still have an easement right in that property, no matter who the owner is. Then we have an easement in gross. This is a utility easement used like by public utility companies like telephone poles or power lines or cable TV or water, sewer pipes, gas lines. Those are public utilities. So an easement in gross is a public utility easement. Now, this statement applies only to an easement in gross. If the need for the easement were to cease, the easement would cease to exist. That line only applies to an easement in gross. If the need for that easement were to cease, the easement would cease to exist. That only applies to the utility easement, the easement in gross. So we just went over, there's either easement appurtenant or easement in gross. But there's other types of easements as well, but they fall under the category of easement appurtenant too. Because there's got to be a dominant estate, servient estate. Easement runs with the land once it's created. But we'll start talking about these other types of easements in a moment after you guys get all your highlights down here.
We once worked with a property in Piscataway that had an easement in gross, and it was because there was a big major pipeline that runs from South Jersey all the way up to North Jersey. I think it was to
Natural
get,
gas.
yeah, we could not, they can't even dig a hole for a plant. That's
Yeah.
how severe this easement was. In order for us to put a fence in, we were working to put a fence in, they had to send someone from Texas to be there the entire time we touched this property.
To make sure that you're not drilling too deep above it and then piercing a hole in that gas pipe.
Yep, yep. And
Or
so
even building a shed
anything,
or a
anything.
driveway on top of it, which could possibly collapse it.
Yeah. So we pretty much were there with the guy, the utility guy for a fence. And the whole time we were working there, the guy was on site. So we were there 5 days. He was there with us 5 days, and then he went back.
That's actually a pretty good thing, believe it or not.
Oh yeah, it was good because if this thing happens, they know we were within the property lines. But it's actually the township had required the homeowner because they had a case against the neighbor because the neighbor wanted the fence repaired. And so this is why they had to repair the fence because of the neighbor. But in order, she was delaying the whole process because she knew she had an easement in the back.
Yeah, but the reason why that company was there that whole time, that gas company was there, uh, was because of this. This actually happened on the Edison South Plainfield border in the 90s. Um, if you guys recall this one, they rebuilt it now, and there's an apartment complex there called Durham Woods. Used to be there in the past, but let me see. Can I share this with you? Here we go. Check this out. You guys, anybody recall this from the 90s, mid 90s, maybe early to mid 90s? 1994. There we go. There was actually somebody that had a backhoe because they were saying well, plenty of people kept complaining that they smelled gas at this apartment complex. And, the gas company came out and they checked it many, many times. Um, but someone else was doing a little digging with a backhoe. About 11:53 p.m. I remember where I was when that happened. They hit that major pipeline. All right. Let's get to the picture already. Come on. So we see the buildup here. That entire apartment complex exploded because that pipeline was hit. Let's try to zoom in and see if we get a picture. Before everybody go our normal way. My car is stuck in the back in the mud. So I guess I have a rear-wheel drive. It's just bushes in front. Just keep fast forwarding through it, otherwise it's just a long video. That's something. The entire complex exploded. It was laid out. totally flattened. See if they show a little bit afterwards here. Let me mute that so we don't get any copyright violations with music. But here's the aftermath. All the melted cars and the entire, so there was an underground pipeline. They hit that pipeline and it flattened the complex over here. But they rebuilt it today. Those pipelines are still going through the same area. If you guys, if any of you actually picked up that your book through me at that Edison Moose, that apartment complex right across the street from that was the Durham Woods complex. That exploded. So it's all rebuilt now. That's why they didn't want you digging there without a gas company representative there, but I don't know what's up with this one. This one looks like they're showing it at night. I remember the Durham Woods explosion happening during the day because I was working at a security job back then, and I remember some personnel rushing out because they were part of I forget what the agency is that takes over all local law enforcement and emergency personnel when there's a natural disaster. But we had a bunch of those people in the laboratories where I was working that were part of that emergency response, and they were all rushing out the door when that explosion occurred, and that happened during the day, I believe. Thought it was during the day. I guess I could be wrong. I don't know. I worked all kinds of shifts back then. But yep, that entire complex got flattened. All right, so easements are either appurtenant or engross. An easement has the right by one party to use the land of another for a specific purpose. And we have an easement appurtenant that could also be an easement by necessity. Easement by necessity is a type of easement for landlocked properties where your property is completely surrounded by other people's, and the only way to get to yours is to cross over theirs. So it's necessary to have an easement like this, called an easement by necessity, in order to get to your property. It's for the purpose of ingress and egress, entrance and exit. Then we have easements by prescription. Remember, those are the ones when you're squatters' rights, when you're using someone else's property for a prescribed period of time, you could claim ownership of it. Easement engross, that's that utility easement. And then we have something called party wall easement agreements. This is for shared housing or attached housing, like townhouses and such, where they're separated by a common wall that's known as a party wall. That separates the two units. And each party is responsible for maintaining their side of the wall, because if they don't, the wall comes crumbling down and nobody has a wall, right? And now we're going to go over how to create an easement and how to terminate one. All right, so remember, an easement's a right acquired by one party to use the land of another for a specific purpose, right? You can't take away someone's easement rights. They can give them up, but you can't take them from them. Now, an easement is a right to enter the land of another for a specific purpose, whereas a license is permission to enter the land of another for a specific purpose. And permission, much like your driver's license gives you permission to drive, it can be revoked at any time. And it's often verbal, not in writing. For an example of a license is this: me saying to you, "Hi, neighbor. Feel free to come over to my house and hop in my pool anytime you like, even if I'm not at home. It's all right." Now we get into an argument, we get into a big fight or whatever. I'm like, "I don't want you on my damn property anymore." Well, I just revoked that license that I created, that permission I gave you to enter my land anytime to use the pool. So it could be created verbally like that. Hey, neighbor, feel free to come by, use my pool anytime you like. I just created a license for you to enter my land to use the pool. We get into an argument, I revoke that license, right? It's as simple as that. It doesn't need to be in writing like an easement. Easements are your rights, and rights are usually written into the deeds themselves or into surveys, etc. So let's highlight. You should already have this one highlighted for an easement, but let's go to page 112 for a second and highlight licenses. Permission to enter the land of another for a specific purpose is a license, and licenses can be revoked at any time. Everybody find that? Page 112? Okay. We good? Everybody got it? Yeah. Okay. So easement, once again, is a right acquired by one party to use the land of another for a particular purpose. They run with the land, meaning it passes on from one owner to the next with the change of the ownership. A party may also have an easement right in the air above the land or a subsurface easement right to what's beneath it or in it, like mineral rights. The holder of an easement only has rights, not necessarily an estate or ownership interest in the land over which the easement exists. Remember, because uh, rights can be sold or leased independently of the land itself. So easements fall into two categories. They could either be appurtenant or in gross. And we learned that in gross is a utility easement. Appurtenant is one where you're touching a neighbor's property. That neighbor can walk over your land for a specific purpose. So easements run with the land. So an easement appurtenant. Here's an example of an easement appurtenant. Lot owner B on the left, lot owner A on the right. You guys see that? Here's where the property line is. Lot owner B has an easement appurtenant right to walk onto lot owner A's property to use the lake. Can lot owner A put up a fence over here? Well, sure, as long as they put a gate there so that's unlocked so that lot owner B can walk over and still get to the lake. Because you can't obstruct their rights. You cannot interfere with their easement right to walk onto your property. Can't revoke somebody's rights. All right. Here's an easement in gross. The utility lines. They cross over the two adjacent parcels of land, but it's by a utility company, whether this is power lines or telephone lines, I don't know. But they're crossing over multiple people's properties. Now, if the easement were to cease to be needed, then the easement would cease to exist automatically. Then we have an easement by necessity. This is an awful example of that. What, you can't cut down a tree and put a driveway in your own property here? Okay, let's just pretend we're in some sort of environmentalist never land where you get the death sentence if you cut down a tree. Okay, so they can't put in a driveway here. So what we're going to need to do is have a roadway that goes over your neighbor's property so that you can get to yours so that you can't cut down those trees in this environmentalist utopia. All right. So that's an example, I guess, not a really good one of an easement by necessity. I got a couple more examples of easement by necessity. I drew my own picture here. Here you got lot owner A, and then you got lot owner B, okay? There's a roadway here for lot owner B to get onto and off of their property for the purpose of ingress and egress. Ingress is entrance, egress is exit. Okay, so can lot owner B park their car here in this roadway?
I would say yes.
Well, whose property is that roadway on?
It's A, but if there's an easement, he has
The
the
right
right
to
to
use it
use
for
it.
entrance and exit, but not to sit his cars and park them there and leave them there. It's not his land. So if the snow falls or a tree falls over that roadway, who's responsible for clearing it and maintaining that roadway's access?
Would it be both parties?
It's
The
lot owner
dominant one?
A's, it's lot owner A's property. Lot owner A is responsible for making sure that the lot owner B's access rights are not blocked off. It's their property, they're responsible for it. Who is the dominant one? Since somebody mentioned that, who is the dominant estate here?
A.
B.
B. It's the person who benefits from the easement is the dominant estate. So lot owner B is the dominant estate here. Lot owner A is the servient because they're letting lot owner B drive over their property to get to theirs.
So I have a question.
Uh-huh.
The dominant one is not necessarily the one that owns the property. The dominant one would be the one who always has access to the property.
The lot owner, yeah, the lot owner that benefits from the easement. So yeah, it's usually not the property owner. The property owner whose property is being walked over, they're serving it up on a platter like a servant. They're serving their property up on a platter, and then the dominant estate is crossing over it. They're the one that's benefiting from that easement.
Okay, but the property owner has to be responsible for everything in regards to the property. So it kind of
Wait,
doesn't.
here. Let me rephrase what you just said. The lot owner A is responsible for everything that happens on their property. You see that? They're responsible for their property. So this roadway that gives lot owner B access to it, lot owner A is responsible for maintaining their property and not infringing on lot owner B's access rights for the purpose of ingress and egress. So heavy snow falls, a tree falls over it, they're responsible for the roadway that's on their property to make sure it's clear so that they're not in any way infringing on lot owner B's rights.
Okay, thank you.
You're welcome. Here's another common example we see. This is something you see in a lot of areas. I think somebody mentioned once in this class that they lived in East Orange. This is a common thing over there where you got houses that share a common driveway then to get to the backyard where they got their parking lots or their garage in the back. Okay. Neither house owner, A on the left in this example and B on the right, has enough space to have a driveway to fit a car in to get to their garage in the back. But if they both share a part of it, there's enough. So they use some of the space from lot owner A's property and some of the space from lot owner B's property. They could put a driveway there. They'll have enough room. The property line is this green line here. The blue lines are just showing the driveway, right? And so there's enough space. Now, neither car should be parking their car and leaving it right here, because that would not be a good neighborly thing to do. Because the likelihood that, I'm going to bring in the groceries, so I'm just going to park it here temporarily, right? Then you fall asleep on the couch afterwards. Then your neighbor's honking a horn trying to get into their property. These are where arguments then start to ensue. So you got to have good neighbors when you have these type of situations here, and keep the driveway clear so that you can get to your property.
So this, I have a question because my friend, she owns a property in East Orange and she has this exact issue.
Uh-huh.
Also, too, what I've noticed is that like the driveway is kind of narrow.
Yeah.
So, and I noticed that like with the houses in East Orange with the shared driveways that it's really narrow to get in. So this is called an easement by necessity.
Yeah, because it's necessary for either party to get to their parking space in the back of their house or their garage in the back of the house. And it's especially important in East Orange because a lot of East Orange doesn't allow parking on the street at night.
No, why? I have a sidebar. Why is that? Because I'm new to East Orange. I used to live in Bayonne,
Yeah.
and before I got parking in my building, like every night I would get a ticket, and I just didn't understand why.
Yeah, why am I getting a ticket? Why can't I park in the street, right?
Yeah,
Yeah, I know.
why is that though?
One would think it's because they got street sweeps going down and cleaning the streets, right? But you know that's not happening, right? So it's like, why the hell is that? It's a good question for your council members in East Orange.
Why things?
I have no idea why I just know that it's like that. I have no idea why. I have no idea why. But hey, it's town ordinance. No parking in the street at night. And and a lot of people don't have parking with driveways. Or if they do, they got them in the back and you got to get to the back somehow. So now in this situation, you got lot owner A and lot owner B over here. Can any one of them put a fence up over here, like blocking off the driveway?
No.
As long as it's not locked, I guess they could. But as long as it's not locked, and then restricting the access to the other party. Because remember, who's the dominant estate here in this situation, and who's the servient estate?
This is hard because they both share it like kind of evenly. So like,
So you got it right. You already answered your own question. It's not that hard.
oh.
It's just it's simple stupid that you try to overcomplicate it now, right? Look, I got it written right here on the left. Who's the dominant estate and who's the servient? Well, they're both dominant and servient estates at the same time, right? Neither one of them would have enough room to drive their car through there to get to the back of their property without driving partially over the other's property. So because of that, they're both dominant and servient estates at the same time.
I have a question.
Shoot.
So the appurtenant part is the part that I'm confused about. So I understand the easement by necessity and the easement by growth. Like,
Easement appurtenant is a type of easement, any type of easement where you have adjacent parcels. So here we have two adjacent parcels, they're touching each other. There's a dominant estate and there's a servient estate. That's basically what an easement appurtenant is. When you got two adjacent parcels of land and you have a dominant estate, an easement that's created, and there's a dominant estate and a servient estate. So that's basically it.
okay, so for this one, it's both
Yes,
an easement by necessity and an easement appurtenant.
correct.
Okay, thank you.
You
We
are.
ac- we actually work with this for our paving, and it's a pain in the butt because when you want to get anything done in this kind of properties, you need to have both consent of A and B in order to do anything, and both of them to have agree on pricing for anything done on this road, like paving, for example.
Yeah.
We would have to send invoice to both A and B, and they have to both say, okay, you can go ahead, but it's not just one owner now. You have to deal with both of them.
Unless you're just going to pave half of it.
Yeah, that's what they usually do. They
Yeah.
split it.
Yeah.
But usually B doesn't want to know of A. Usually.
Yeah, well, I'm saying it could also get down to the point that if they don't agree, you could pave half the driveway up to the center.
Yeah.
You know? Hey, listen, not all neighbors are good neighbors. Good neighbors should be understanding in this regard. Hey, we're both on the same, we're both got the same issue here. We both need this driveway repaired, but maybe one's a cheap old bastard and he just doesn't want to spend any money. So what are you going to do? Pave just half of your driveway? That's an option. Or you cover the whole bill because they're just a cheap old, what are you going to do? Yeah, that could create situations. I understand it, yes, but it is what it is. I hate that saying, but it is descriptive. It is what it is. All right, so now we're going to go over that once again. We've gone over this early when we skipped to chapter 20, the adverse possession, the squatter's rights. This is one that is perfected. An easement by prescription is perfected in a court of law. Okay. You don't just automatically become the owner of someone else's property because you've been using it against their permission for a long enough period of time as defined by law. You got to go to court and prove your case and then claim the ownership through the court system. So, easement by prescription, some people call it squatter's rights, or adverse possession. Hell, you could go to YouTube and search for how to become a real estate investor through adverse possession. And you're going to find tons of idiots explaining how you could break the law, but they tell you that it's perfectly legal. And they give you these courses on how you could invest by breaking in someone's house and changing the locks and filing court papers for adverse possession. And in the meantime, you rent it out and you're collecting rent for a house you don't own. I've complained to YouTube, so many complaints I filed with YouTube, that these people are going to get someone in trouble because they're basically guiding them on how to violate the law. And YouTube says it's not against our terms and conditions. Okay, so if I sell a gun or I show people how to make a gun on YouTube, is that against your terms and conditions? All of a sudden it is. Why? Because it's illegal. Well, these people are showing some other people on how to break the law. How's that different? So these videos are all over social media. They guide you on how to become a real estate investor without investing anything by breaking into someone's house and changing their locks and then claiming adverse possession by filing a court document, then renting it out. It's a good way to land yourself in jail, guys. Okay. So when you use someone else's property for a period of time as defined or prescribed by state law, you could claim ownership of that property that's being used. Now, you don't become the owner just by making the claim, though. You can't then start renting it out right away. To perfect this easement by prescription, it requires a court action called a suit for adverse possession, or sometimes it's called a suit to quiet title. To claim the ownership of the land and have the judge rule that you are the owner or you're not the owner because you've been using it for that prescribed period of time as defined by law long enough against the owner's permission. So the use must have been continuous, hostile, adverse to the owner's title, exclusive, and without the owner's approval. Additionally, the use must be visible, open, and notorious. It's not like you've been sneaking on their property for years and using it, or you got an underground doggy fence that's electrified around the property. You know, it has to be visible, out in the open, notorious that you've been using their property, and at the risk of the owner's title, them losing it. So the prescriptive period in New Jersey is 30 years for improved lands and 60 years for unimproved wetlands or woodlands. And it is required, so you have to use that property for that period of time before you could successfully win an adverse possession claim in New Jersey. However, there's a conflict in the law in New Jersey because there's another law, the common law, which says after 20 years, you have to file the claim. So years ago in New Jersey, somebody was actually filing an adverse possession claim because they said they've been using the property for 60 years and they could prove it. And the argument was, yeah, but there's a law in the book that says that after 20 years, you had to file the claim. Why'd you wait so long after? Well, we wouldn't win the claim because there's a 60-year period. Oh, so you got two laws that are conflicting with each other. So the judge, instead of legislating from the bench and creating a de facto law by setting a precedent and ruling on this case, because that's not what judges should be doing. You know what happens when judges do that? Then you get problems like they did with that whole abortion thing a couple of years ago. Remember, that was a whole outcry here in the United States. What did they call that law? Roe versus Wade, right? The whole Roe versus Wade thing. You had some politicians on the left screaming that, oh, these are long established laws for women's rights to health care, that they have a right to an abortion, right? Well, who wrote the law? When was it proposed, and when exactly did Congress vote on it? There was no such law that was ever created. It was actually one judge who ruled in a case where a lady claimed that she was raped and she wanted an abortion. Okay. And then the judge ruled on there and said she could do it. And that set the precedent for the next 50 years that all courts upheld because of the precedent, the de facto law that was created by a judge. And that's not a judge's job. That judge should have kicked that case out and not ruled on it because there was no law pertaining to it. It's up to Congress to create the laws. Right. So as you can see, all kinds of complications occurred over the years over this, because now 50 years later, somebody actually brought it to court all the way up to the Supreme Court, where they eventually ruled, yeah, there was no law. This judge had no right to do this. And so therefore they kicked it out and they scrapped it. It's actually not a law because judges do not make laws. The politicians do in Congress. Now, of course, politics being the hot topic, you had all these politicians on the left who were pro-abortion were lying and saying that it was a law, it's been long established, and the Republicans on the right, they want to take away your rights, No, they didn't. They just said, sit down and write a law if you're so passionate about it. How come they don't want to do that? Because politicians are cowards. They don't want to upset people on hot button topics, right? And so if they voted one way, they knew they were going to alienate some of their voters, so they just don't vote they just don't create the laws. This is why politicians are cowards. And for a lot of different topics, they don't vote on these things. So all this did now is it just put the law back into the state. Now it's up to each state to create their own law because there's no federal law on it. So unless the Congress creates a federal law that'll be the law of the land, which they did not do. It just got kicked back to the states. So each state now has to create their own laws pertaining to abortions. Okay. Now it's the same kind of stuff that's happening right here in New Jersey with this adverse possession thing. The judge didn't want, except the judge here they ruled the right way. They did not make a ruling on it. They kicked it out of court and they kicked it back to the politicians. They said, politicians created this problem. There was one common law in place, and politicians in New Jersey created 2 additional laws that all conflicted with it. So this is a problem created by the politicians. So he kicked it out of court and kicked it back to the politicians to fix. So politicians rewrote the law. They said, okay, we're going to do away with the 30-year and 60-year law, and we're going to go with the 20-year common law. However, that legislation is still sitting on the docket to be voted on. This happened 17 years ago. It's still waiting for them to vote on it 17 years later. In the meantime, nobody has won an adverse possession suit in New Jersey because all these laws are conflicting with each other. So I'm telling you what it's going to eventually be, but for exams, it's not there yet because the politicians didn't vote on it yet. So for exams, we're still going to study the 30-year and the 60-year law. 60-year for improved lands, 60 years for unimproved land. Now, if only one person was making the claim, and they weren't there for the full 30 or 60 years, through the process known as tacking, successors in interest, like a landlord and a tenant, an ancestor, an heir, seller, and a buyer, they could add one person's time of possession onto theirs, combining them to reach the prescriptive period, or tacking on one person's time onto another, combining them to reach the prescriptive period. Okay, that's where they get that term tacking from. You tack on one person's time to another, combining them to reach that prescriptive period that then they can make the claim successfully. So how do you prevent somebody from taking your land through adverse possession? Well, an owner can take legal action against any adverse possessor. First of all, you should walk your property at least once every 30 years and then take legal action against anybody who's adversely possessing your property and using it or squatting on your land. Or you could cut off their access, right? This stops the continuous use and resets that time clock that's needed to claim adverse possession. Or you could give them permission. That also resets the time clock too, but you can't claim adverse possession against somebody who gave you permission to use their property. Well, say this. I find out you've been using my property for the last 60 years even, and it's improved lands, so you only needed to use it for 30. But you still haven't filed an adverse possession claim. Well, I'm going to send you a certified letter in the mail that gives you permission to use my property till the end of the week. And then you got to go. By giving you that permission, I reset the time clock, and you never filed the adverse possession claim yet, so now you can't. Okay, so this is the way to prevent somebody from gaining adverse possession or being able to successfully claim it. This is why even shopping centers, sometimes they rope off certain sections of the shopping mall or the parking lots at least once a year to try to prevent the public from being able to claim a public easement. Like, take a look at Rockefeller Center in New York. You guys all familiar with Rockefeller Center, where they got that ice skating rink and they put up the big Christmas tree every year in New York City? You guys know what I'm talking about, right? So, you know, Rockefeller Center, that's actually private property. That's not a public park. Okay, it's private property. Okay, on the Rockefeller property. Now, various times throughout the year, they rope off certain sections that even if it can't be accessed for one day, this resets the time clock so the public cannot claim adverse possession, because every year they rope off one section, different sections of that whole thing every year for at least one day. Same thing when they put up a Christmas tree or they shut down the ice skating rink, right? One day is all it takes throughout the year, and they reset the time clock. Now, an easement by prescription cannot be claimed against publicly owned land, government-owned land. So let's do the highlights if you did not yet on page 111. I know we did it in chapter 20 where we discussed this, but chapter 6, page 111, let's highlight that an easement by prescription, when you use someone else's property, an easement by prescription is created by using someone else's property. So if you get a question that says, how do you get an easement by prescription, or what type of easement is created by using someone else's property for a period of time as defined by law? An easement by prescription. And what is the prescriptive period for a property that has a structure on it? What is the prescriptive period for a property that has a structure on it?
30 years.
30 years. What if there is no structure, but there's a paved road or a gas pipe that runs under it? Is that an improvement? Is that a man-made improvement? Well, then that's 30 years as well. But if there are no improvements at all on the property, it's just woodlands with a fence around it even, it's
Then
60
it's 60 years.
Mm-hmm. Correct. So you're highlighting all this now. An owner can halt the process by specifically granting permission for use or by cutting off the continuous use. They forgot to write something in there. You should probably write it right above that, or take legal action to get them removed from the property. See, they even say here, the owner of a shopping mall or plaza often closes the area off one night a year to avoid any claim that the public has gained an easement. Since the property cannot be accessed, it stops the continuous use part of the property. So even if it's only for one day, well, it wasn't continuous, so you're not going to win an easement by prescription case in court. And tacking successive periods of continuous uninterrupted occupation by different parties may be combined to reach that prescriptive period, to tack on one person's time of possession onto another to reach that prescriptive period. Either way, you don't automatically become the owner. Legal action must be taken to perfect the easement. And until that legal action is taken, the owner can have those 3 ways to prevent somebody from gaining an easement by prescription: by cutting off their continuous use, by taking legal action to get them removed, or by granting the permission. Because you can't claim an easement by prescription with the owner's permission. So the legal action is often referred to as a suit for adverse possession, or it could be simply referred to as a suit to quiet title. Okay, everybody got those highlights and those notes down? Throw a poll up on screen for you guys to answer. All right, once again, there's a poll up on the screen, the attendance poll, if everybody could answer that. All right, somebody's not answering the attendance poll again. There we go, thank you. All right, everybody got these highlights and these notes? Okay. So in chapter 20, we had these same notes. They were written a little bit clearer here. And then we also learned that once somebody, a squatter, has established title because they took you to court and they've proven it and they were awarded the ownership, there's no recourse that the owner has anymore once they lose their property. So to prevent such loss of title, every person having a right or title to real estate must inspect their property at least every 30-year period and take action against any adverse claims. Now, it is also possible for property owners to lose their properties through something, well, they're not losing their property, but they're losing the use of their property through all kinds of governmental red tape. When the government puts all kinds of restrictions, whether it's environmental or building codes or local zoning codes, that there's so much red tape put into place, they basically make your property useless, that you can't use it anymore. If that's the case, that property owner can sue the government for something that's known as inverse condemnation. They basically condemned your property without condemning your property. There's nothing you could do with it because of all the red tape and legislation on restrictions of how you could use your property that have been created. So it's on the owner to prove that the government has taken away the rights to use their own property in this way, and they could sue then to be compensated for that because of all the regulations that they put in place, strangling the property owner's use or ability to use their own property. All right, now here's a picture from Piscataway, actually. This is a listing that I had. It was owner of a property. Here's their property. And neighboring the property, there's a big grassy corner, okay? And you got 2 streets that run this way, right around that corner. We had to put down in the ad that that the corner lot is not included in the sale and is not part of the property. We don't want to mislead any potential buyers because it looks like they got this big side yard that they even had a volleyball net on. This property owner was always cutting the grass here because the city never did. So this property owner was also always maintaining that corner property lot. So even though they were using it, they couldn't build a shed on it or put a fence around it or anything like that because it's not their property. It's publicly owned land. So they could always go and ask the city to give them the land or sell it to them, and then they could be taxed for it now because they own it now, and now they have a bigger lot. Or if they want to, they could say, we're not gonna cut the grass anymore. You need to send city workers out now to regularly come out and cut this grass every week. Or 2 weeks or whenever they do it, but you cannot claim ownership, easement by prescription, just because they've been cutting the grass here for the last 30 years or 60 years or whatever. But they could ask the government to give them the land. That's known as public grant, when the government gives property to a private individual. Here's an example where you see the entire black outline. Here is the property boundaries. Okay, this person has a nice big property. I know of someone that actually did this right on Wood Avenue in Linden. Now, what they did is they took the property, then they put a street on it. They built a cul-de-sac street. That's like a dead-end street with the big circular end where you could turn around. And then they subdivided it into 6 smaller properties where they built 6 houses, and they sold 6 houses there. Now, this street that they built, that they named, in their plans, when they submit them to the city for approval, they could either dedicate the land, that means giving it to the government, and then it becomes for a public use like streets, schools, and parks, and then this will become a city street. Or since that street was built on their own property, it would be a private road. So when you submit plans like this for approval, you have to state there whether you're dedicating the street or you're keeping it private. Why? Because it was built on your land. Okay, so here we got a little, we do this at the end of every chapter where I read out those key terms, and you guys got to tell me what you think the corresponding key term is, and there's no penalties for wrong answers. So that's the kind of way this guy reads off the rules in this show called Cash Cab. Anybody ever see this on TV? Cash Cab? All right, so basically it's a game show. It takes place in this comedian's taxi cab, because between gigs, I guess he drove a taxi like many comedians do. And so this guy, he decided, hey, you know what? I'm going to get some sponsors, and we're going to get prizes, and we're going to give money out to people who ride in my taxi cab. We're going to make a game show out of it. And it actually became very successful and was on the air for many years. Went off the air, and then it came back for a couple more, and then it died out again. But this was a great game show. They should have it out there. I think it was a great show, because if you answer 3 questions wrong, he pulls over wherever you're at and kicks you out of his cab. So the worst case scenario, or best case scenario, you could actually win money and get a free taxi ride. So are you ready? Do you want to play? Let's see one of his questions here. Let me also crank up the volume to make sure you get it loud enough.
What term for a dead-end street means bottom of a bag in French? Oh.
Y'all heard that? Did everybody hear that good or no?
No, I didn't hear it good.
You didn't hear it good? Okay, here, let me also optimize the video then. And okay, to share the audio is shared. Let me shut off my video, and let's rewind it and play it again for you.
What term for a dead-end street means bottom of a bag in French? Ooh, ooh.
He said, what term for a dead-end street means bottom of the bag in French?
Cul-de-sac?
All right, let's take a look and see.
What term for a dead-end street means bottom of a bag in French? Ooh, ooh.
Is it cul-de-sac?
I'm afraid it is. Cul-de-sac is correct.
There you go. You just won $50 if you were on the Cash Cab.
Yay.
All right.
What term?
Okay, I got another one for you. Unfortunately, I only have 2 of these, but yeah, this is pretty cool little break for you right now from the studies. How about this one? Can anybody get this one?
These next questions are worth $50 each. What Chinese spatial philosophy is used to determine sites for graves and house design?
What he said, if you did not hear it, was What Chinese spatial philosophy is used to determine sites for graves and house design?
Feng Shui.
All right, let's take a look.
That is correct.
There you go. You got it. Feng Shui.
Yay, I get all the money.
Look at that. $100 you would have had if you were in the cash cab. Unfortunately, you're not in the cash cab, so you get nothing. You get our congratulations. There you go. Hey. Little pat on your back there. All right. But yeah, okay. Interesting. It's an interesting show. Look at it. He's got all the lights that, people don't know until they step into the taxi cab. All of a sudden, you go boom, and the sounds and all the lights flashing, and they're like, "You entered my cab. It's the cash cab. This is a game show that takes place in my taxi cab." If you guys never heard of it, they still have reruns of it all the time on Game Show Network. Yeah, check it out. It's actually an entertaining show. Sometimes people, it's stressful too, because sometimes they get all the way down to the end. He gives them lifelines where they could make phone calls to people, or they could pull over on the street and ask somebody on the street, if they don't know the answer to something, But they get one of each of those, and if they get 3 strikes, they're out. They pull over right wherever they are and they kick them out. Interesting program. It was a good program.
Next question.
Cash cab. I should write that one in my in the class links Word document. If I don't have it there, I should write that in there. Okay, well, anyway, here's another easement by prescription. Here's another way. Let's just look at this picture. Just look at this picture here. You got lot owner A on the left, lot owner B on the right. Here's where the actual property line is, and here's where a fence has been sitting. Now, that fence has been sitting there for the last 30 years. So, owner A at any time can take owner B to court to claim ownership of this area of land that they've been using for the last 30 years. How could lot owner B prevent lot owner A from gaining ownership of this area of their land?
Access.
They could cut off their direct access to use the property. Here you go on the right-hand side. They could cut off their direct access. They could give permission, or they could take court action. Now, they could cut off their access by taking this, by putting a fence where it actually belongs, right here on the property line. But who put this fence here to begin with?
A.
You don't know. It could have been lot owner B. They were just trying to be a good neighbor and put the fence inside their property a little bit. And then lot owner A has been using it, and then they sold it to someone else, and they assume now that this is their land, when really that fence belongs to lot owner B, and they put it up, and they just were trying to be good neighbors by putting it in their property a little bit. I got a fence on the side of my house. It's actually in on my property further than my property line, because there's a couple of trees over there. I'd have to cut down the trees to actually put it up where the property line actually is. All right. So I put the fence in a little bit in on my property, but now the neighbor, I guess they died, and somebody else bought the property. Their kids sold the property to someone else, and now they're thinking that property is theirs. So I got a survey, though, that shows otherwise. So, but I'm letting it go for now to see if they'll take the expense and cut down the tree. If they ever try building anything over there, I'm going to let them know they're doing it on my property. But in the meantime, if they want to cut down the trees and bear that expense, by all means, go ahead and do it. So, lot owner but let's take a look. Maybe lot owner A did put the fence up over there. Can lot owner B just take down that fence? That was built on their property?
Yes.
I guess you could do anything, right? But there may be consequences to that. Lot owner A puts up a brand new fence and they put it up right there on your property. Yeah, I'd be pretty ticked off too. But let me ask you a question. If lot owner A parked their car in your driveway, can you take a sledgehammer to it? Why not? Same thing as removing their fence. You're destroying the fence that they just put up. If you're looking in the eyes of the law strictly, right? So what's the proper way about doing it? Taking them to court and getting them to remove the fence that they put on your property. It's like calling the cops to get the car towed that they parked in your driveway, same kind of a deal.
I had a question. When you sell a house, does the house property lines get marked out? No, right? You just assume what it
When,
is?
when you buy a house, you should get home inspections, right?
Yeah,
Now, what do you get home inspections for?
the home itself.
That's your typical home inspection. But do we do title searches?
Yes.
What does a title search uncover?
On liens and stuff like that.
So it looks for financial claims on property or other ownership interest that somebody may have had, right? So you're inspecting. So it is a type of home inspection, though, right? About the ownership, related to the ownership of the property and any financials on it, claims, right?
Right. But what about the
Okay,
size of the
okay, hold on a second. I'm getting there. I'm trying to build up my case here. Okay. So you do the home inspection to physically search the property and, for the structure and maybe oil tanks or something that may be under the ground, things of that nature. You do the title search to find out about the ownership of the property and any liens that may be on it.
Right.
But then we also get surveys done. We pay a surveyor to measure out the property lines. And on the survey, they would show you pictures of any structures or fences or anything that are intruding onto your property.
Okay, so that's part of the closing, the survey
Well,
part.
Well, it's up to you to buy it, to get the survey. Most lenders will require it,
Okay.
but yet it's the buyer's responsibility to do any inspections. But yet
Because
that would
yeah,
uncover that issue of where the fence is, not who owns it or anything like that. It just goes over, the surveyor just measures out the property and shows you what's on that property and if there are any easements on it.
okay.
Don't assume. You said, do you just assume where the property line is? Well, don't assume anything, because you know what happens when you assume. Well, on this next slide, I got an old clip from a comedian called Benny Hill. If any of you guys remember this old British comedian, he was funny as hell. Here he explains assume. Well, I got to turn up the volume on that, and let's get that going again.
You must never assume, because when you assume, you make an ass out of you and me.
That guy was a trip. Benny Hill, if you guys never heard of him, look him up. He was a trip. Yeah, he was before his time. Perverted old guy. He actually had his dad on the thing too, on the show too. The guy who was always the bald guy, short bald guy, he was always slapping his head and kicking him in the butt. That was his father. Anyway, great show. Benny Hill. All right, here I'm going to have an attorney explain to you easement by prescription from the eyes of the law, from an attorney, because I did a lot of research before I tried teaching these classes and putting these slides up together so I could explain things and be more comfortable in being positive that how I explain things to you, I'm actually doing it in the right light and not showing you the wrong things, okay? So I actually did a lot of research and I couldn't find much information on easements by prescriptions. I did a lot of research, and I also came across this attorney. The recording kind of sucks, so excuse the pops and the lower volume. That's why I try to crank it up a bit here.
For an attorney or for...
And we can listen to her talk and explain. She's from a different state, like in Wisconsin or something like that. But she's explaining how property laws just generally work in general for attorneys for and she's specifically talking about adverse possession, and uses some of the terminology. Remember, what are the terms that are needed in order to claim adverse possession? You have to have been using someone's property against their permission, out in the open, hostile, adverse to their title for a prescribed period of time as prescribed by the law in your state. Different states have different prescription periods for this law. But let's check this out. Let me just minimize the videos, and here we go. Let her talk now.
Or just a property owner, I think a lot of times people don't even realize that this body of law exists. Maybe when you own your first home or you get your first survey, you start to realize how important boundaries can be. My name is Jessica Shrestha. I'm an attorney at Wheeler, Van Sickle, and Anderson. That's here in Madison, Wisconsin. The concept of adverse possession is that, well, first everyone has a deed to their property. There's a legal description, there's a boundary, whether it's a lot or something else, specific distances, and that's your boundary. But as everyone knows, it's hard to figure out where those are, and a lot of times actual occupation on the ground doesn't necessarily match the real boundary lines. Sometimes it's a matter of a few inches, but sometimes it gets to be, we're talking feet, acres, a whole 40-acre parcel sometimes. And it turns out that if you occupy and use an area of property for long enough and treat it as your own property, the doctrine of adverse possession makes that your property by law. It's more complicated exactly how that applies, but that's the basic concept. Over time, property can become yours even if you don't have a deed that describes it. Adverse possession comes up most often for a typical property owner with a fence. That's really the classic example, and that has been for as long as we've had real property and the law of adverse possession. Someone will construct a fence, and even if they get a survey to tell them exactly where the property line is, they might construct their fence a foot inside their property. They want to make sure they can stay on the other side, for example, or a foot on the other side. Sometimes it's a greater distance. And over time, they forget. Or maybe they didn't know where the exact boundary was in the first place, and that fence might become the boundary by operation of adverse possession. Same thing goes with lines of trees and hedges, or even people might place a shed on a neighbor's property. And that's in a city lot. The same thing, though, can happen with pasturing cattle or with fences for cropland. When a client or a potential new client comes to me and they think they have a boundary dispute or maybe an adverse possession situation, to start, I think the easiest way to think about it is you have to ask the basic questions: the who, what, when, where, why, and how. The who is really important. Who are the parties involved? And with adverse possession, it's not going to just be the current property owner necessarily. Do you have a governmental entity? Who owned that property 20 years ago? The what sort of property is involved? Is it hunting property, a city lot? Those are important things to know about property and deciding if you have adverse possession. When? Are we talking 20 years of adverse possession? Was it occupied between 1930, 1950? What time period? Where? How much property is involved? What is the actual boundary line that's in dispute? And why? There's a recent case, again, Wilcox versus the state of Hines, that told us it is important why you were possessing the property. Did you intend to possess it? Was it with the permission of the true owner? Did you think it was your property? And then very importantly, how? What were your acts of possession that constitute adverse possession? When I have all of that information, I sit down and I think, does this equal adverse possession? I compare it to the case law. And then I start to think about possible defenses and different related doctrines maybe that could come into play, such as the doctrine of acquiescence or easements. Attorneys should know that the statute isn't going to answer their question in most cases. You need to look at the entire body of law that has developed over time. The adverse possession statutes actually codify the common law, and so there are different elements even in the cases than ours are listed even in the statute. So the elements of adverse possession are continuous, exclusive, open and notorious, and hostile possession, whereas there is no reference of most of those terms in the statutes themselves. Attorneys also need to know that you shouldn't just look at either the first case or even the last case. It's been a long and complex doctrine that has evolved over time, And a good place to start is probably the latest case, but there are plenty of cases from over 100 years ago that I still reference and that are still relevant good law that you will need to be aware of. Part of why I wrote my article is sometimes it's really hard to find a good summary of adverse possession law. A lot of the treatises will have it, but that's on a nationwide basis. And our state, along with a lot of other states, has developed the law in its own way. So I think the best way to sort of follow along and know what you should be looking at is to just go through the cases. You're going to have to do your case law research. Hopefully my article will give you a good starting point, but from there you just have to get into the topic.
Okay, so if that's from an attorney's perspective there, showing you how they go into determining whether somebody can actually successfully claim adverse possession or not. You know, she said it's not even written in the law what the requirements are, even though we know the requirements are for adverse possession or hostile, out in the open, exclusive, without the owner's permission, but those things aren't even specifically written in the law. But that's what's needed in order to claim adverse possession. So, interesting.
For an attorney.
Okay, now I got a couple cases here to show you about adverse possession, actual cases. And some of these are interesting. They're all in different states here, but the laws are basically the same. It's just the adverse possession period is what differs. Here's an example of criminals that are using the law. You know, how those YouTube videos are showing you how to use it, but also here's some example of criminals just taking over people's property to gain possession.
A bit more bizarre business story. We're going to talk about the headlines about the young man.
Let me optimize this.
Moved into a $2.5 million mansion near Miami without paying a dime. We first told you about this story Friday morning, but we're now learning that this has become a national trend, and some of the people doing it are even connected to an anti-government group the FBI classifies as domestic terrorists.
That's those sovereign citizens. You guys probably watched Cops or Live PD. And you see those sovereign citizens, they claim, I'm a sovereign citizen. I am a traveler. I do not obey your laws. They do not apply to me because I'm not a citizen of your country. I'm just passing through it. You know, I don't need a driver's license because I'm not driving. I am traveling. You know, all kinds of nonsense like that. Well, that's these same idiots here.
Tone, one of the poshest zip codes in Florida, is abuzz this morning over what is happening inside this $2.5 million, 7,500 square foot waterside mansion. The bank foreclosed a couple of years ago, but now a 23-year-old named Andre Barbosa has simply moved in.
Nobody's happy. We all spent a lot of money to live on this street.
Barbosa is using an obscure legal concept on the books in every state called adverse possession, which says if you live in an empty home for a certain amount of time, it's yours. Adverse possession is being attempted all over America. Susan Weidman took over a series of homes in the Atlanta area.
I filed adverse possession back in February as Susan Weidman at the DeKalb courthouse. Okay. So I'm not just, transient squatter here.
This $3.3 million house near Raleigh, complete with an elevator, got caught up in this whole mess when Sean Pendergraft claimed he owned the house.
It's not a scam. Everything we're doing is lawful.
There have always been squatters, but the housing crisis has put the phenomenon on steroids. Some of the people using adverse possession are connected to a sometimes violent anti-government movement known as sovereign citizens, who believe U.S. laws do not apply to them.
A police officer walks up to someone who is claiming a house now belongs to him without any basis at all, is handed a big sheaf of documents which are incomprehensible. And I think very often the officers ultimately feel that they're forced to go back to headquarters and try and figure out what's going on before they can actually toss someone in the slammer.
I met a young sovereign named Robert Peterson who moved into this foreclosed home in Idaho.
They're the enemy. They're the enemy of anybody who wants to live free.
One expert on sovereigns found evidence to suggest that Andre Barbosa, in that mansion in Boca Raton, is connected to a sovereign group called Divine Province, based on the language Barbosa used to justify moving into the mansion and the fact that his name is on the group's website. Before you get any ideas about trying to use adverse possession, consider that the sheriffs forced Robert Peterson out of this house, and remember Susan Weidman? Arrested for racketeering. And Sean Pendergraft, also arrested for obtaining property by false pretense.
All the legal arguments he may make or the documents he may file will all end up leading to the same conclusion, and that is that he gets kicked out because he has no legal right to be there.
As for Andre Barbosa, he may be running out of time in that mansion in Boca. Bank of America has now filed a claim in court claiming it is the rightful owner of the home.
It's so crazy that they're arguing that the law's on their side.
They are, and they're kind of 1/3 right.
Fascinating story. All right.
No, 1/3 right.
A bit more, but
Yeah, a little bit of knowledge can be a dangerous thing, stressing the little bit part. All right, let's look at some more cases of adverse possession.
Now a warning about the risks more and more people are taking to get a house for next to nothing. It's an obscure law some hope to cash in on, but often land in jail instead. Our Chris Trankman joins us live.
You guys are going to get a trip out of this one. This is that sheriff from Florida, Polk County, Sheriff Grady. This guy is a trip. He's a comedian, but he's a strict enforcer of the law. But he's got jokes.
Live in Polk County to explain more on this, Chris.
Well, the sheriff says some people never learn. This is the house in question. It's valued at $160,000. It's in foreclosure, and both deputies and residents here are baffled why a couple thought by breaking in, turning on the power, water, and cable, they would
Sorry about that. Just making sure we're recording here. Yeah, we are.
have the right to own the house without paying for it.
With the homes being vacant, it just takes neighbors in the neighborhood having their eyes and ears open.
Danny Rodriguez says residents along Echo Lane noticed a locksmith changing the locks and moving trucks unloading furniture into this vacant house. As the Homeowners Association president, familiar with his neighbors, Rodriguez suspected a scam.
I knew a little bit about adverse possession just from doing some research at saying you need to be in the home for 7 years, and I knew they weren't here for 7 years.
Adverse possession is a Florida law from the 1800s that applies to unoccupied farmland. The property appraiser alerted sheriff's deputies about Sherry Fields and her husband after they filed for the obscure law. They were charged with burglary and grand theft. Meanwhile, Sherry Fields is a teacher at Fort Meade High School.
Come on, girl. You know, you got a college education. You should know better than that. But anyway, we gave her a field trip to the county jail.
Sheriff Grady Judd says more people are learning about adverse possession from websites online, mistakenly thinking they can use the law to take over an unoccupied house for free.
Of course, we all know if it's on the internet, it's got to be true. Well, what they didn't see on the internet was my Facebook page that says, "We will put you in jail."
You know, we work hard for our homes and what we have, and it's not fair for someone to just come in and take somebody's possession like that.
And the sheriff says the school teacher and her husband are going on another field trip, this time for a crash course on Florida law. They'll be in a courtroom tomorrow. We're live in Polk County. Chris Trankman, ABC Action News.
See how he's a trip?
Now a warning.
All right, let's see another case here. Now, New Jersey is a lot like California. As a matter of fact, you know, we're a very blue state. We take on a lot of those same liberal laws like California does, and therefore New Jersey becomes a tenant rights state. When it comes to residential property, it looks out more for the tenants than it does the landlords. And you'll see here as an example where you could get people that if they know the law, they could twist it to their advantage, and then it becomes a nightmare to get squatters out of your house. All they got to do is show some fake made up paperwork and try to act like they're a renter. And then the cops don't know any better. The cops can't rule on these things. Cops, they're the enforcers of the law, right? But they are not the interpreters of the law. That's the judge's job is. The judges interpret the law. Cops enforce the law. And when things like this happen, somebody needs to file a complaint, take it to court, and it's a long, drawn-out, messy process. But let's take a look at at some of these claims here. Let me see if this is the same one. I'm not sure if this is this one or if this is another one in Florida, where it's interesting, where a property was not divided properly before it was sold at an auction. And the municipality screwed up, the auction screwed up, the previous owners screwed up. Let me see if that's this one or if this is the one about the renters.
Caught in the act, how one woman stopped a group of squatters from moving into a vacant home she owns.
Yeah.
Good evening, I'm Jackie Parks.
And I'm Todd Carley, 23 ABC's Mark Christian is live tonight from a home in Oildale where those squatters were trying to take up residence. Mark?
Well, guys, if you think if someone is living in a home illegally, it'd be a simple case to get them out. Well, squatters move under the radar to try to move in very fast, and in some cases even changing the lock so they can move in before the owner finds out.
I saw like about 20 people at my property trying to move in as fast as they could.
After her previous tenant moved out, the home had only been vacant for 10 days.
Unfortunately, some of these squatters have gotten pretty sophisticated.
Rena Chanty was getting her home ready to put it up for rent when a neighbor called to tell her someone was trying to move in. The squatters were moving in a refrigerator, a washer and dryer.
Basically everything a house needs. They were even putting up their decoration pieces, and they had changed the locks.
When deputies arrived, the squatters were still in the process of moving in. Though not commenting on this specific case, Ray Pruitt with the Sheriff Department says squatters can take refuge under the California tenant law and have even been known to falsify rental agreements.
Once they're in that property, in some cases it's very hard to get them out of that property without legally evicting them.
In cases like this, law enforcement's hands are tied because if the squatter presents what appears to be a legal agreement, it comes down to he said, she said.
Sometimes we can't determine if the squatter's in the home legally or not.
They know the system and they know how to play the system.
Fortunately for Chandy, the squatters did not get that far and could not provide any documents to law enforcement.
At that moment, the cops told me it was my word against their word, and I had to prove that I owned the property, which I had the paperwork on me.
So right now, Chandy is checking her house daily until she can officially get it rented. In the meantime, she's asking her neighbors to keep a watchful eye until that place gets rented. Back to you, Jackie.
All right, and we have the one more this is a perfect example, like the cases where they on YouTube they teach people how to become YouTube investors in real estate without actually owning a real estate, but using adverse possession.
How come you're running away from me? If it's all legal, stay and talk to me. There may be a good reason why this guy didn't want to stick around or explain how he helped two families move into this Coconut Drive house. Terrence Smiley tells me this man he knows as Enchino Hernandez offered a deal on this house that was too good to pass up.
He say he have a house. Go check it out if you want it. We can do business.
Turns out the guy dashing off in a hurry doesn't own the house, but Smiley says that guy offered to rent the house to Smiley for $500 a month. The guy denies that. He claims he just charged Smiley $190 for advice about a form available at the property appraiser's office and a little-known law called adverse possession. Adverse possession allows someone to take ownership of abandoned property if they live on it and pay taxes on it for 7 years. What's happening in the Bay Area is a lot different. An 8 on Your Side investigation found some people are turning the adverse possession law into a money-making scheme, taking control of vacant properties and then renting them out.
Do you believe that you've committed any violation or crime or misdemeanor? No.
That's what Steve Bible told me more than 3 years ago. He moved 31 families into homes he didn't own, filed adverse possession papers, and collected monthly rent. He's now in prison, serving 5 years for fraud.
The Hillsborough County property appraiser tells me there's been an explosion of adverse possession forms coming through his office in the past few months. So we set out to find out who's filing this stuff.
We visited house after house after house, all of them listed on adverse possession forms we obtained from the appraiser. Most are vacant. But at this townhome, Alice Fugate had a big surprise after she signed a lease with the real homeowner.
We had squatters in here the day before we moved in.
These new renters found other people's stuff inside. And 2 doors down at another home on the adverse possession list, we found a cable TV installer waiting to do his job.
They can stay there if nobody kicks them out.
Stetson Law professor Daryl Wilson says adverse possession is a technically legal way to take over abandoned property if the right steps are followed.
You would think that the person who owns the property would come and police their property. The law helps those who help themselves.
Where we draw the line is breaking into somebody's home.
But the Hillsborough Sheriff's Office takes a hard line on adverse possession.
It belongs to somebody, so stay out of it. If you go inside of it, you break inside of it, we're going to arrest you for burglary and theft.
So you the landlord here?
No, I'm not.
Then why'd you rent it to these guys?
I didn't rent it. They went down to the courthouse and did that.
This guy tells me he doesn't charge people like Terrence Smiley rent. They just pay him for his adverse possession expertise. He later agreed to talk to me, but the phone number he gave...
The mobile number you have called is no longer in service.
These tenants could end up in the cold. Detective McKinnon says the sheriff's office typically gives renters in adverse possession cases 30 days to move out.
Innocent families, it just bull crap, man. Really bull crap. You work hard for your money.
In this case, and so many others, adverse possession adversely affects people's lives. Peter Bernard, News Channel 8.
All right. And this is a very interesting case with a property line dispute. How do you know where the property line is? One of you guys just asked me this a little while ago, and I said, well, you do a survey, right? Well, look at this interesting case here where a property line is running right through a house and a pool.
This is a wild story. New from Orlando, there are big questions tonight about what is going to happen to this house in Wadeview Park now that a boundary dispute has reached a whole new level. Check out this new fence. It splits a pool in two. Channel 9 Shannon Butler is live there in downtown Orlando. It's just south of downtown. And Shannon, this fence has neighbors scratching their heads and wondering what will happen next here.
Yeah, if you walk down this street here in Wadeview Park, it looks normal, right? There's a house on this lot. There's no house on this lot. But if you look behind the bushes here, you can see the guy without a house has put a fence on the guy with a house, making it clear where the property lines stand. Now everybody is asking, what's this guy do now? This home along Harding Street sat vacant for years, all because of a boundary dispute. The MLS listing says, quote, the pool and the garage are partially on the adjacent parcel and not included in this sale. Huh? It's such a mess that realtors don't even want to touch it. This realtor posting about it saying, quote, my job as a realtor is to help people buy and sell properties. Sometimes my job is to help people not to buy. So the house was just sold at an auction, and now what was a dispute has been taken one step further. The owner of this lot seemed to have put up a fence right through the pool of the other guy's lot, splitting the garage and that pool in half.
Now, the reason why he did that is because he's trying to protect his property, right? Because if you just let someone else use it for a period of time as defined by law, they could claim ownership of it. Now, he has no problem giving that property up and taking the land if the city gives him a permit to build a house on his property next door that does not have a structure on it. The thing is, it doesn't comply to the zoning laws. The lot is too small to build a house on. But if he has that additional property where it goes right through the center of this house, then he can. So he put up that fence and says, okay, until this dispute gets settled with the municipality, I'm not giving up the ownership of my property. So I'm going to put that fence up where it belongs right there. But I'm willing to take it down if the city gives me a permit to build on a smaller lot than normally allowed. Now, what do we call that when you get permission from the municipality? What do we call that permit that allows you to violate the current zoning laws? It's called a variance. So you apply for a variance. that allows you to vary from the current zoning rules to build on a smaller lot than normally allowed in this example right here. And this, remember, they just showed you a listing where this property was listed for sale, and they said, well, the pool and the garage is not included in this sale because it's got the fence going through it. Even the reporter was like, huh? Well, I guarantee you it is this lady's listing. This lady lives across the street and she's a realtor. I bet you that it is her listing, because the way that she sounds, she seems like she's making a lot of trouble for this property owner without the house on the lot. You know, he's trying to get a permit for a variance. Okay, the city gives him a variance and gives him permission to build it. The way variances work is you still cannot build it unless you send out a letter to everybody within 300 feet of your property, and nobody takes up an issue with it. And if nobody takes up an issue with it, well, then you can move through with that variance and build that house. But if somebody objects to it, and I think she objected, and now because I guess she wasn't able to sell this house because he put up that fence through it, and now she's all bitter towards him. And she's the neighbor across the street as well. Okay, you could see for yourself.
That's where we stand now. We have a brand new owner of this house, and this is how they choose to make their statement to the new owner.
Lisa Sconyers is a realtor and has lived across from the two properties for years. The history is long and sordid, but the easiest way to explain it is that both lots were owned by the same person, a house on each. He then sold them to the new owner, who then cleared the lots to build one big house. But that owner went into foreclosure and the lots were sold to two different people. So now this house is over the property line of the other lot. In the end, Sconyers says this could have all been avoided.
The city of Orlando didn't permit this the right way. What they should have made these people do is they should have made them replat the property into two separate properties. They never did that.
Now, we have reached out to both sides and the city. We're still waiting to hear back. Now, when it comes to this property here, this property owner is trying to get a petition. He's gone around to the neighbors, asking the neighbors to give him an exception to back it up because this lot isn't big enough for a house, to allow a house to be built there. Now the neighbors are saying, I don't know if I can back you on that because you asked us to do that before you did this, and this problem still isn't solved.
Yeah, the neighbors, the realtor across the street. She's the one that's making up the trouble over here, you can tell.
We're live in Orlando. Shannon Butler, Channel 9 Eyewitness News.
This is a wild story.
So, all right. So, party wall. A party wall is a common wall with that's common with attached housing. You know, in medieval times, it was just like it sounds. It was a wall that was built with stone that straddles the property line and separates two properties. But now we got shared housing, and we have often just a simple common wall that separates two units that are side by side from each other. That is also known as a party wall, and there will be a party wall easement agreement saying that each party has an easement right in the other side of the wall, and both parties are responsible for maintaining their side, because if they don't, the wall comes crashing down and nobody has a wall. But either way, what is that? A party wall? Let's see, we add it to our definition list. It's a wall of a building that straddles the boundary lines between two owners' lots. That's all it is. It's common in shared housing, like duplexes, side by side, or townhouses, etc. Okay, everybody got that? Party wall. All right, so here I got on this one slide, party wall, license, easement, and encroachments, which we didn't go over yet. An encroachment is anything that crosses over the property line, like part of a building, fence, driveway, or any other installation that illegally extends beyond the land of its owner onto the neighboring property. I know we get this question all the time. Well, what about a tree? Well, a tree is not an installation. However, if you do have a tree that's from the neighbor's property, it's hanging over your property, you have the right to just imagine wherever your property line is, there's just imagine an imaginary property line that goes straight up into infinity. Okay. So if you got any tree branches from the neighbor's property hanging over to yours, you can trim those branches. Check with your local laws, though, with your local municipalities. They may have some wacky rules that for any kind of tree trimming that you need a permit from the city. But basically, the way that it usually goes is you got your property line and you got your imaginary line above your property line. If the tree is hanging over it, well, you could cut that part down. Okay. But let's just say the neighbor builds a fence, a shed, even a garage, or, and we just saw this instance, even part of the house or part of the garage and the pool that went over the property line. That is called an encroachment. So an encroachment is anything that crosses over the property line, like part of a building, fence, or driveway, or any other installation that illegally extends beyond the land of its owner onto the neighboring property. So here's something that a student told me in an old class. She said, well, the word encroachment also has the word roach in it. So much like a roach, it's something you don't want on your property. Okay. So there's another way of understanding the word encroachment. It has the word roach in it, and it's something you don't want on your property. But it's any kind of installation that illegally extends beyond the land of the property owner. Okay. And I got these other definitions here too, if you want to snap a picture and have them all in one place. There you go. You got them all in one slide here. The party wall, a license, what an easement is, and an encroachment. Okay. Here's the first junk call of the day. 800 number. Yeah. All right. Okay, so how do we create an easement? Okay, so here's that on the bottom of page 111. How do you create an easement? Well, by express grant of the permission, by getting the permission of the property owner. By a deed conveying or creating the easement over the sold land. Granting the new owner an easement over the grantor's remaining land. By long-time usage, like an easement by prescription. However, an easement must be perfected in a court of law with an easement by adverse possession. Or by necessity, for the purpose over which would be for ingress and egress when you have landlocked properties. Or by easement in gross. That's a public utility easement. Interesting little factoid. You know that most municipalities have easement rights in the first 6 feet of your property line. Beyond that first 6 feet, if they wanted to, they could put a telephone pole. They could plant a tree in front of your house. I know this because my city did that. I had a house at one point that they came around with all these arborists. Remember we had that issue in New Jersey with the Japanese beetle that got into New Jersey? And we had just about every municipality had state, county, and all kinds of arborists, environmental companies. They were climbing trees. They had the arborists climbing trees looking for the Japanese beetle. And if they found a Japanese beetle in your tree, because they burrow into the tree and make nests inside of it to reproduce, what they would do is they would cut down the entire tree, have a crane pick it up, lay it down in the street, and feed it into a giant chipper right there in the middle of your street, the entire tree. So I had a double lot, but it wasn't quite wide enough that I could put a 2-family house on it. You know, I found this out later because they changed the zoning law while I owned it. So I looked up the cost of cutting down those trees so I could put up that 2-family or convert the single family to a 2-family. And it was expensive. You know, I had these huge 150-year-old trees on my property, right? And there was 5 of them. And the arborists, you know, they came down and I asked them, I was like, well, what are they looking for? They're looking for this beetle, you know? They're like it's black and yellow, and it looks like a crab with big claws. It's really menacing looking. And I was like, oh, okay. So it was an invasive species. It just destroys the trees and reproduces. So it got into our country somewhere through the ports of entry in I guess the Newark port. Came in through some of the shipping there, and then got into the environment, started spreading around. So I was like, well, what do you do if you find one of them in my tree? They said, well, we'll cut down the tree. I was like, ooh, I hope you find them in all my trees. So there's no charge to me for that, right? So they climb up the first tree in the driveway, nothing. Second tree, nothing. Third tree, nothing. Fourth tree, nothing. The fifth tree, all the way in the back, they found a Japanese beetle. However, they said we can't get to it unless we chop down the other 4. Yeah. So they chopped down all my trees, and I actually got a video of it somewhere. I can't find this video. I got to find it. It's in one of my old computers, which I got to hook them up and go through the hard drives. But
Are these those lantern ones?
No. Japanese beetle. Let me see if I can show you a picture of it. These things are pretty menacing looking, actually. Let me see. No, that's not it. That's not definitely it. I just look up Japanese beetle. They're coming up with these like regular looking beetles. No, that is definitely not it. Let me see. Japanese beetle. Those are not the Japanese beetle. Maybe it was a different kind of beetle. I don't know. This thing looked like a lobster, a black lobster with big claws, and it was jet black and yellow. Let me see. What kind of beetle has that then? Maybe I got it wrong. I thought it was a Japanese beetle. Well, so far, the only beetle I found is a Hercules beetle that looks but that's not it either. I don't know. Apparently, there's a lot of different beetles out there, and I'm just looking for trying to find the Japanese beetle. It had it had long horns. It was pretty big in size. It's the one that they found and pulled out, and they put it in a plastic jar, but they said they got to get it to a glass jar because it could eat through the plastic jar. It was about this big, and it was jet black and yellow stripes. Yeah, it had the chompers, those claws that were kind of looking like this. But it had 2 of them. This is just showing one. Here's that stink bug that you're talking about. I have no idea. Anyway, they're telling me it was the Japanese beetle, but when I look up Japanese beetle over here, I see what looks like a regular beetle. So I don't know. I can't find a picture of it right now, but they cut down they cut down all 4 of those trees to get to the one in the back, because in the back they couldn't get back there. There was an apartment complex and stuff. They couldn't get back there with the crane, and there was power lines and everything. They weren't going to disconnect them, so the only way to get to it was for them to cut down the trees in front so that they could then get the crane and then open it up on my property. And they actually lifted the tree over my house, and they lifted the tree over my house, and they lifted the tree over my house with the crane, and it was dangling over my house. And I was like, oh, please drop it on my house. Please drop it on my house. What a lawsuit right there. I was trying to sell the house anyway. That was a fixer and flipper investment property. So they lifted it up over the house, and then they put it down the street, and they put it into the chipper. I got a video of it on my old computer somewhere. I filmed it on my cell phone, my old cell phone. And it's on one of my computers somewhere. I don't know where the hell. Let's see if I can find it. But that's because they had that Japanese beetle in there. So how do we get to talking about a Japanese beetle anyway? Oh, because after they cut down all those trees, they were asking me if, what kind of bushes or trees I wanted to replace it. Because remember, these are environmentalists, and they're normally against cutting down trees. So they want to replace it with some kind of other plants. I was like, nope, get out of here. I don't want nothing. I was planning on building a 2-family house there, Then the city changed the zoning law on me. Now I had 5 feet too short in order to build a house. So I wasn't able to do that. And then one day I'm coming home from work. I'm coming and I'm living in this investment property. So I'm coming home from work, and I see a city truck driving down, a tractor trailer flatbed driving down, that has a bunch of little sapling trees and a backhoe on it. And I was like, oh, they better not have. Well, pulled up to the front of my house. They planted a tree right smack in front of my house, and they put a letter in the mailbox that said, I'm responsible for watering it, maintaining it, and if the tree dies, I'm responsible for paying for that tree, which was like $2,000. And I was like, this is ridiculous. I didn't ask for it. I didn't want it. Now I got to maintain this tree. And they put it right in front of my house. Do you know a lot of people that follow feng shui concepts? There's no way in hell they'll ever buy that house now with a tree directly in front. It's the way that it works. So, but either way, your municipality has a easement right for that first 6 feet of your property. If they want to, they could put in a sidewalk, 4-foot wide sidewalk with that 2-foot wide gap. They could run power lines, utility lines for gas, water, sewer, all that stuff along that area. That's usually where they got the shutoff valves, so you can't prevent somebody from going on that part of the property. How do we terminate an easement? Well, when the purpose for the easement no longer exists, and that statement only applies to an easement in gross, the utility easement, or when the owner of a dominant estate or servient tenement becomes the owner of the other. They bought the other property. Well, you don't need permission to walk over your own land, so that would terminate that easement. Or the dominant estate can give up their rights. Nobody can take your rights, but they could give them up. They could release the easement right to the owner of the servient estate, maybe for a little cash osis, or by abandonment. However, courts have ruled and determined that simple non-use of a property does not constitute abandonment. You'd have to prove it's what's in the person's head, that it was their intent to abandon the property. So I don't know how you do that. That's very difficult to do. When my dad was still alive, he owned property in Pennsylvania, and he was like, one of these days I'm going to move back there, one of these days, And he always said that his whole life, but he never did. So as far as the neighbors are concerned, they were like, oh yeah, the last time somebody was here was like 30, 40, 50 years ago. So they abandoned that property, but really, if you can't really win that claim, because I can tell you, my dad always wanted to go back to that property. So trying to prove abandonment, simple non-use does not constitute abandonment. You'd have to prove the person's intent was to abandon the property. And that would be the furthest thing for the truth in that case. So that's how you would terminate an easement. All right. So once again, licenses, they could be revoked. A license is permission to enter the land of another for a specific purpose, and licenses, just like your driver's license, it can be revoked. I give you that example about the pool. I said, hey, neighbor, come on over, use my pool anytime. Created a license to give you permission to enter my property to use the pool. Get into an argument, I don't want you on my damn property no more. I just revoked your license, as easy as that. That's all it takes. Nothing needs to be in writing. Okay, so encroachments here, if you didn't highlight it yet, on page 112, highlight when all or part of a building, fence, or driveway or other installation illegally extends beyond the owner of the land. Well, that's an encroachment. And if it's there for a long enough period of time, that person can claim an easement by prescription. Okay? I've had situations like this where I went in for listings and the neighbor built the garage halfway over onto the neighbor's property. I don't know how they could have possibly got the permit to do that. Maybe they built the garage without a permit. How did the city overlook such a thing with their inspections and such? But nonetheless, it happened. That garage was there for a period of years. I told that property owner, you need to get them to remove that garage or give them or sell that piece of property to them that it's sitting on. You know, otherwise they could claim ownership of it if it's there long enough and you didn't do nothing to fix the problem. They built it over on your property. Now you're trying to sell it. What buyer would want to buy a property where the neighbor built their garage halfway over the property line? You really want that issue cleared up before you buy the property, unless you're buying both properties, right? But short of that happening, you'd want that issue cleared up before you buy it. Otherwise, you're buying into a headache, right? So, deed restrictions can only be placed in properties by private parties, and those restrictions placed in deeds are called restrictive covenants. Covenant is a legal promise. These are restrictive legal promises that you agree to abide by. So, restrictions are placed in deeds by private parties, not by governments. Governments have their own powers, which we're going to go over in the next chapter. Restrictive clauses added to deeds when property is conveyed. They are established by the seller to restrict a future owner's right to use the property. They run with the land. They pass on from one owner to the next once they're created. And these restrictions last forever, unless the creator of the restrictive covenant added a sunset clause that says that the restriction will go away after a certain period of time or upon the happening of a certain event. Or in rare cases, a court can remove it, but they're not likely to. Most subdivisions, like developers that build condo complexes and such, or even if they're just building houses, just standalone houses in a big complex, they often put restrictions in the deeds, in a master deed somewhere, that whether they could put up a fence or not, or you know, if their property can be later subdivided or not. If your municipality has a rule on it, and then your deed has a rule because it has a restrictive covenant, which rule do you follow? Your municipality has these zoning laws that say what the minimum lot size is for you to be able to build on. So let's just say that you have a 100 by 100 foot lot. Your city has a minimum lot size requirement of 50 by 100. Technically, you could, according to city rules, you could tear down a house, subdivide it, and build 2 houses there now, right? But if the developer that built that house put a restriction in the deed that the minimum lot size can only be 100 by 100, which one do you follow? The city's rule or the developer's rule?
City.
So according to the city's rule, you'd be able to subdivide it and put 2 houses on that lot. Remember when I told you when there's 2 rules that cover the same topic, the more restrictive rule will prevail? You always follow the more restrictive rule. So the developer's rule is the smallest the lot size can be is 100 by 100. So you can't subdivide it and you can't put another house on it. So which one is more restrictive? Even though the city allows smaller lot sizes, the larger lot size requirement from the developer is actually more restrictive. It would not allow you to put 2 houses on it. So you'd have to follow that rule. Okay? And let's see. What type of estate and land is based on a restriction that was written in the deed? Fee determinable, also known as a defeasible or conditional fee. And that's the condition that you don't subdivide it to smaller lots, smaller than 100 by 100, right? In that case. So right next to deed restrictions / restrictive covenants, because that's what we call restrictions placed in deeds. And then right there, page 104, actually at the beginning of this chapter, chapter 6 is where we went over it. Fee determinable, defeasible fee, or conditional fee estate is the estate and land that is based on a restriction. Ownership based on a restriction. As long as you don't violate the restriction, you remain the owner. What kind of estates and land are based on restrictions? Fee determinable, also known as a defeasible fee or a conditional fee estate. And that was back on page 104 where we went over that. The 3 types of estates and land. Everybody got that? All right, we're done with this chapter. Let's do the key terms to review and then we'll break for lunch. So before we get started, in key terms number 1, next to letter A, cross out the word indefinitely and write forever or a lifetime. Cross out the word indefinitely and write forever or a lifetime. Okay, everybody got that? Next to letter E, as in Edward, where it says ownership as long as, right after that, based on a restriction. Based on a restriction, next to letter E, where it says ownership as long as, well, as long as you don't violate the restriction, so it's based on a restriction. Then next to letter F, where it says amount of ownership, cross out the word of ownership and write or kind of interest in real property. Or kind of interest in real property. We crossed out the words of ownership and we wrote or kind of interest in real property. So it should just read amount or kind of interest in real property. Let me know when you got that. Everybody got that? Okay, then next to key terms 2, we're going to make some changes as well. Next to letter D in key terms 2, cross out the word lien and write legal action, and then put in quotes or brackets foreclosure. Legal action, then put in brackets the word foreclosure. And then go down to letter J and cross out the word will and write the word may above it. So next to letter J, it says third party who will gain eventual ownership. You're crossing out the word will and you're writing the word may. And then next to letter L, you're not crossing out anything. You're just going to write above the first word possible. So possible future interests of an owner. Okay. Okay, so let's do this. Key terms 1, ownership lasting forever or a lifetime.
Freehold estate.
It is. 16 is A, freehold estate. A permanent right to use another's land. Permanent right to use another.
Easement.
6 is B and E. Ooh. Somebody's speaker's a little bit, their microphone's in front of their speaker, I think. That's causing that feed. Husband's right in wife's property.
Courtesy.
Courtesy, 3 is C. Simple right to use part of an adjacent parcel.
Easement appurtenant.
Easement appurtenant.
7 is D, easement appurtenant. That is correct. Ownership as long as, or ownership based on a restriction.
Fee determinable.
14 is E, determinable, correct. Amount or kind of interest in property. Amount or kind of interest in real property.
Estate in land.
13 is F, estate land. Correct. By the way, the feedback will be reduced if you lower the volume a little bit on the speakers, or if you move them, or the speakers behind them. All right. A right used for utility lines on another's land.
Easement in gross.
10 is G, gross, correct. A right of access to landlocked parcel.
Easement by necessity.
8 is H, correct. Wife's right in husband's property.
Dower.
Dower.
Dower, 5 is I. 5 is I, correct. Right sometimes acquired through usage. A right sometimes acquired through usage.
Easement by prescription.
9 is J. Transfer by sale or gift.
Convey.
2 is K. Property that benefits from an easement. What do we call the property that benefits from an easement?
Servient.
No, the one that benefits.
Dominant. Oh, dominant.
That's the dominant estate. 4 is L. Most complete ownership of land possible. Most complete ownership of land possible.
Fee simple.
15 is M as in Michael. Fee simple. Any easement, encroachment, etc. Any easement, encroachment, etc.
Encumbrance?
Is encumbrance. 12 is N. Placed against real estate, a worker who has not been paid.
Construction lien?
1 is O, construction lien. Building intended, building intruding on another's land. Building intruding on another's land.
Encroachment.
11 is P, encroachment. Okay, key terms 2. Structure owned by 2 adjoining landowners. Structure owned by 2 adjoining landowners.
Party wall.
9 is A, party wall. A claim against all property someone owns.
General lien.
1 is B. Claim against one parcel of real estate only.
Specific lien.
14 is C. I noticed that legal action may be filed, that legal action being foreclosure.
List pendants.
Correct. 7 is D. Lender's claim against real estate. Lender's claim against real estate.
Mortgage.
A mortgage lien. 8 is E. Temporary permission.
License.
4 is F. 4 is F, license. A right to use and possess for a limited period of time. Ooh. Did you guys hear that? Here, let me
hold.
1 second. Let me just mute everybody here for a second, and then just unmute yourselves if you guys are answering it, because there's some feedback there when I'm reading the questions. So, which one was that? A right to use and possess for a limited period of time.
Leasehold.
Correct. 3 is G. Property taxes are 1.
Involuntary lien.
2 is H. The order in which liens are paid.
Priority.
They're according to their priority. 10 is I. And the priority is determined by the date that they're recorded in the public records. So 10 is I. Third party who may gain eventual ownership.
Remainder man.
11 is J, correct. The tract over which an easement runs. What do we refer to the tract of land over which an easement runs?
Oh, the servient estate.
The servient estate. 13 is K. Possible future interest of an owner. Possible future interest of an owner.
Reversionary.
That's 12 is L, the reversionary interest. Adding successive periods of usage. In order to gain an easement by prescription, you add on one person's time to that of another. It's called tacking. 15 is M. Complete ownership until someone's death.
Life estate.
6 is N, a life estate. Financial claim against real estate. Any financial claim against real estate is a lien. 5 is O. And mortgage or equity loan, for example.
Voluntary lien.
Voluntary lien. You went out of your way to get it. So that concludes chapter 6.